The appointment is pointless.
Hi, chat. What an exciting day. I feel like so many people have been waiting for this for so long. I'm sure the Honorable Tiffany Adams, you guys might know Tiffany as the Fit Lawyer ATL, and Jim, aka Hal, aka HappilyAngryLawyer, aka HappilyAngryEsq. I think they've probably been waiting for this day longer than any of us combined. But it's here. We finally have the appeal. We've got the brief, MOUNK TOUNK's brief, filed with the Court of Appeals. It's 70 pages. We're gonna go through it, and I'm really excited to see it. There will be, as we go through, there will be some repetition of issues we saw raised at the trial court level. Obviously, since we're in a different venue, we're gonna see those issues, most of them I expect, repeated, but I think we're gonna see some stuff we haven't seen before. This is a blind read for me. I'm just thrilled, crossing my fingers, saying my prayers. I don't like what happened to Antonio Sledge, aka MOUNK TOUNK, and I'm hoping this is finally the stage where the right thing is done. So, happy to see you guys joining. It's always good when we do a stream like this and get back together. D. Johnson's here first in the building with the thumbs up. Hey to Grammy. Hey to Mr. Face saying first, but I see D. Johnson first. There can only be one. Charlotte's here. Good to see you. Good morning. My BFF Biff, or Almond Brown, says good morning. J-Town, good to see you. Candace, Kinanu, BluEyedHillBilly. Look at the whole gang here with Mona, Isabella. Always good to see you for a YSL stream. My big Mr. Big Play Bray. Candace saying free MOUNK TOUNK till it's backwards. There is a MOUNK TOUNK emoji, you guys, by the way. So we've got that going. Unfortunately, it's not a feature that we can make free for you guys, but if you do have a membership, please use those till your heart is full. Hey to Brittany, good to see you. We got Big Dog Fluff. Always love that name. Hope you and the family are doing well. Peter Steele, we love our Steels here in this building. Factual Lie, good to see you. Vague and Ambiguous says it never should have happened. And again, I really think it comes down to Whitaker didn't have a light bulb moment go off yet, and I really don't think she thoroughly read the motion to vacate the void sentence, the first major filing that we looked at. I really don't think she fully read it. I think she saw an issue from the intro and the outro and said, oh, okay, yeah, the math is wrong, cool, because she didn't address any of the other arguments raised in her ruling. She just let them go off into the wind. So, criticizing her for what I think was a rash decision at the probation revocation hearing, and also I'm going to criticize her for what I'm assuming is that she did not really give the motion to vacate void sentence the time of day to read. The more recent motion that they filed at the trial court level, remember Whitaker said, go take it to the appeals court first, and then if you need to, come back down, and then we'll look at this motion. So, Batty QB, good to see you. Yep. Look at these two right hand in hand. Taybiz TV says, what up though, good people? So glad you're covering this cat. I miss you, Taybiz. I need to get caught up. I was busy with this work this weekend and had to do some traveling. And I know I have like a million things. I can't even summarize what you did because I haven't watched it. But guys, Taybiz has had Hillbilly True Crime and a few other updates over on the Mickey Steins case this weekend. Like stuff that just happened. Stuff that I'm sure he hasn't talked about in his previous streams. I'm behind, so I can't give you the 411. So we've got to go over there and check it out and see what Taybiz has been up to. So good to have you in the building. Hey to Kimberly. Hey to Makia Mama. Amanda, good to see you. Miss Kells, look at everybody. I'm so thrilled that so many people are still here following in to see what's going on with MOUNK TOUNK. So we're going to get into it, you guys. We got the long cat. See, Red Bunny's back in the building, too. And J Money, Classy Beats is tonight, you guys. Club Classy. Good to see J Money coming over here from Classy's channel. We'll be hanging out there tonight to listen to some music, so come hang out. The link is in the description. Good to see you guys. Good to see you guys. So without further ado, we've got this appeal. 70 pages. We're going to get into it. If you want to watch over on Twitch and help me get Twitch going, especially if you're, just listening in the background, you don't really have time to pay attention to the chat. If you want to help me out, and I think Twitch wants you to have 4 streams where you have an average of 4 viewers. So whatever that criteria is, why they do it, it is what it is. But if you are not paying attention to the YouTube chat anyway and want to watch over on Twitch, if you have Twitch, that'd be cool. But other than that, here we go. Make this big. We'll embiggen it. And let me drop the link in case you guys want to read along. It's also in the description, but the link to the filing is in the chat. Because again, 70 pages, I know it's a lot to listen out loud. Sometimes it's easier to see it with your eyeballs. So table of contents, and when you see appeals, you guys, it's nice because the table of contents should, and usually hopefully does, have a little section that gives you a top-level overview of the arguments. So, in brief, we've got the void sentence on count 30. We've got the trial court erred. We're going to see all these throughout the document, but this is a quick way if you're ever wanting to get a top-level overview of the arguments in a brief. You should be able to look right in the table of contents right there. But we're going to read the whole thing. Oh, Bailey's is over on Twitch with the purple icon and the, the anonymous profile picture. All the case law that they're going to reference. And shout out to attorneys for putting this stuff together, because having to do this would drive me nuts, but they've got to do it. So let's see, comes now, we're in Georgia, Antonio Sledge, and submits his brief of appellant, showing that the trial court's order granting defendant's motion to vacate void sentence on count 30 should be vacated because it improperly vacated, right? So we're arguing that the first thing that Judge Whitaker said, oh yeah, we're going to vacate that sentence. We're taking issue with that because even that wasn't done right. So it improperly vacated only count 30, when the entire original sentence should have been vacated as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. And we're going to see Clue v. State. We've talked about this before. The trial court's order also violated the double jeopardy clause of the Fifth Amendment by improperly increasing the appellant's sentence on count 1. So now we're getting, this is a new argument. Pitts v. State from 2020, it's a Georgia appeals case. The trial court erred in resentencing the appellant in his absence. So remember, when Whitaker did that resentencing, there wasn't a hearing. And we looked at the form. On the disposition, it was notated that Tiffany Adams, the Fit Lawyer ATL, was present. She was not present. There wasn't a hearing. Antonio Sledge wasn't there. But Whitaker did the resentencing, just whoop-a-doop. But Barber holds that a criminal defendant has the right to be present at all critical stages of the proceedings against him. Lastly, the trial court erred in finding that the probation revocation of a void sentence was valid. So there you go. Jurisdiction. We're going to skip this jurisdiction. Let's get right to the enumeration of errors. So, again, the court erred by not vacating the entire sentence due to the void sentence on count 30 because it was a package deal. The trial court erred by improperly increasing the appellant's sentence on count 1 in violation of the double jeopardy clause of the Fifth Amendment. So, because Whitaker took this extra time and said, oh, I'll just lob it over here, we'll put it on count 1. You're resentencing on the different count then. There's a problem. The trial court erred by resentencing appellant in his absence in violation of his right to be present at all critical stages of the proceedings against him. And the trial court erred in accepting the appellant's guilty plea, which was clearly neither voluntary nor knowing, in violation of the appellant's right to due process and Uniform Superior Court Rule 33.7. So this is where we're going to get into that mysterious, we have one signed on December 27th, but then a new version was made in court on the 28th. And we have all of that hubbaloo that we talked about in the most recent stream we did on MOUNK TOUNK. I linked that in the description if you want to go revisit that. We rewatched the plea hearing and heard how it all went down. 5, we have the trial court failed to advise the appellant of his right to withdraw his guilty plea when the trial court rejected the first negotiated plea agreement, as required by Uniform Superior Court Rules 3310. Thus, his conviction must be reversed. 6, the trial court's revocation of 5 years of the appellant's probation constitutes an illegal sentence because the appellant's underlying sentence did not contain any special conditions of probation. The state's petition to revoke the appellant's probation did not allege the violation of any specific special condition of probation, and the trial court did not find that the appellant violated any specific special condition of probation. And now remember, this is a major issue. This made up the bulk of the motion to vacate that was filed, I want to say maybe end of May. That was like the major issue, right? Is, was it knowing how this plea hearing went down and stuff was changed in the middle of the plea hearing? But also this probation revocation, what was, there's the general, there's the specifics. What was the alleged violation? There aren't even special conditions listed in the final plea. So how can they say that this was done properly? And now this is something that if the appeals court doesn't make a decision that's favorable to MOUNK TOUNK here, the trial court will still be visiting these issues. Whitaker just said go to the appeals court first. The trial court erred by taking judicial notice of appellant's trial testimony during the probation revocation hearing. The appellant received ineffective assistance of counsel during plea negotiations and sentencing. So I know a lot of you have been waiting to see this. The ineffective assistance of counsel. Appellant received ineffective assistance of counsel during his probation revocation hearing when counsel failed to object to false information as to the appellant's criminal history was read into the record by an unsworn witness. Whew. So there we go. Let's get through the background. It's been a while, so I think we know what we know, but let's go through it again. Let's look at their recitation of the statement of the case. Mr. Sledge was originally indicted on May 9th, 2022. Does the date May 9th just stand out to everybody now? Under case number, we're going to just shorten it to 73. The original indictment charged Mr. Sledge in count 1 with conspiracy to violate the RICO Act, and in count 30 with possession of a firearm by a convicted felon, 16-11-131. The language of count 30 in the original indictment. So these bold parts are important. I'm going to let you know. I'm going to emphasize them for those that are listening. So the text reads, and the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, do charge and accuse Antonio Sledge, aka MOUNK TOUNK, with the offense of possession of a firearm by a convicted felon, 16-11-131. That's it. Just the possession of a firearm by convicted felon, 131. For the said accused, in the county of Fulton and state of Georgia on the 5th day of December 2021, did knowingly and without lawful authority possess a firearm, to wit, a handgun, after having been convicted of a felony in Indictment 94 in the Superior Court of Fulton County, Georgia, for the offenses of participation in criminal street gang activity, aggravated assault with a deadly weapon, and aggravated battery on the 10th day of January 2018, contrary to the laws of said state, the good order, peace, and dignity thereof. Now, we've gone over this. I think a lot of us know why this is going to be an issue, but I think it's taken some time to grasp, so we're going to read it all. On August 5th, 2022, the District Attorney, Fani T. Willis, Madam D.A. Willis, re-indicted the case under case number 72, right? So now we're moving into the second indictment. With respect to Mr. Sledge, the caption of the re-indictment was not revised from that of the original indictment. And remember, that means we're saying firearm by convicted felon, not during commission of a felony. And we have 131. So, in this new indictment, as in the original indictment, the re-indictment's caption stated that count 1 charged conspiracy to violate RICO, and count 30 charged possession of a firearm by convicted felon, 131. However, within the body of the reindictment. Count 30 was altered in two ways. The first change to count 30 in the reindictment was the name of the offense charged. It was changed from possession of a firearm by convicted felon under 131 to possession of a firearm by convicted felon previously convicted of felony involving the use or possession of a firearm. 133. Oops. Oops. Secondly, the predicate convictions alleged in count 30, drawn from Mr. Sledge's 94 conviction, were changed from participation in criminal street gang activity, aggravated assault with a deadly weapon, and aggravated battery, to possession of a firearm during commission of a felony and aggravated assault with a deadly weapon. All other wording in the reindictment, count 30, remained the same, meaning the reindictment alleged exactly the same elements as in the original indictment, despite the fact that the reindictment's count 30 purported to charge 16-11-133. Accordingly, despite the retitling, the reindictment continued to allege a violation of 131. Whew. On December 1st, 2022, just 27 days prior to Mr. Sledge entering his plea under the reindictment. This is so important. This is, if you missed this, if you haven't watched the last two updates on MOUNK TOUNK, this just is something that it pissed me off. It pisses me off. It still pisses me off. This whole time frame of this December 2022, nobody's getting bond, and then we have plea deal palooza pop off after Christmas. Like, it's the most obvious gang. We're just going to hold you. You can't go anywhere, but now we need you. So we're going to suddenly offer you a plea. So back on December 1st, 2022, D.A. Willis and Adrian Love, ADA Love, filed the state's motion in limine on the substance of the indictment. In said motion, the state correctly argued a well-established principle in Georgia. So we're giving them their props, which mandates that when the caption of an indictment and the substance of that indictment conflict, the substance, not the caption, of the indictment controls. So, see? The state's well aware of how this works. They correctly argued it around the time that it matters. And they correctly argued it in this case. The state quoted the following: "It is immaterial what the offense is called if the averments of the presentment are such as to describe an offense against the laws of the state. It is not the name given to the bill which characterizes it, but the description in the averments of the indictment." So thereafter, the state sent its first proposed plea agreement to Mr. Sledge through counsel on December 27th, 2022, the evening before the final plea hearing. Less than 24 hours later, on December 28th, 2022, Mr. Sledge attempted to enter a guilty plea pursuant to the negotiated plea agreement signed on December 28th, 2022. They attached the transcript. Throughout the plea hearing, the state repeatedly interchanged the terms possession of a firearm by a convicted felon and possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. And we rewatched that, I think, several times, but that's linked in the description as well if you want to go back and revisit that, in its description of count 30 of the reindictment. The first time Mr. Sledge's charges were identified during the plea hearing was in the following exchange between ADA Love and Mr. Sledge. "Do you understand that you are being charged with the following offenses?" "Yes, ma'am." "Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?" "Yes, ma'am." "As well as possession of a firearm by a convicted felon?" "Yes, ma'am." Now, you guys know what's missing here, right? This is 131. "Yes, ma'am." "As listed in count 30 of this indictment?" "Yes, ma'am." Next, ADA Love asked Mr. Sledge, "Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as an OCGA 16-11-133, is 15 years in prison?" ADA Love changed the charge mid-sentence, beginning with possession of a firearm by convicted felon, referring to 16-11-131, and concluding with, as in OCGA 16-11-133. Later in the plea hearing, Mr. Chamberlain, Judge Glanville's litigation manager, while discussing if Mr. Sledge could be released without a sentence on count 30 as required by the negotiated plea agreement, stated to the court, "We don't know if that was the previous indictment, but as of this case, 72, this is the second indictment, possession of a firearm by a convicted felon, no bond. By calling for sentencing to be withheld on count 30, the negotiated plea agreement required Mr. Sledge to be released with neither a sentence nor a bond in place as to count 30. The sentencing court, in consultation with its staff, determined that Mr. Sledge could not be released in such a manner. Accordingly, the sentencing court rejected the first negotiated plea agreement. The sentencing court then recessed in place, giving the state and appellant's counsel an opportunity to negotiate and obviate the problematic terms to the satisfaction of the court and its staff. The parties entered into a second negotiated plea agreement, and Attorney Love proceeded to... Oh, are we switching? Guys, we gotta make fun of Jim for this one. Because he made fun of, this is a pet peeve of his. Yeah, we're supposed to be calling her ADA Love. Ooh, Jim. Uh-oh. But now it's Attorney Love. Proceeded to describe certain revisions to the sentencing court. The second negotiated plea agreement was never reduced to writing. The most significant change reflected in the second negotiated plea agreement related to the sentencing on count 30. Instead of withholding the sentence on count 30, as was proposed by the negotiated plea, and this is important, you guys. So originally, sentencing was supposed to be withheld on count 30, but this second negotiated plea provided for Mr. Sledge to be sentenced immediately. This is to make it work. So as required by 16-11-133, the sentence on count 30 would be 15 years in length and run consecutively to count 1. Also new to the second negotiated plea agreement was the state's agreement not to object to the termination of the balance of probation after 10 years. The sentencing court adopted the second negotiated plea agreement as tendered and negotiated. An oral pronouncement of sentence followed. Now, let's see how they argue why this is problematic. So the sentencing court's rejection of the first negotiated plea agreement and acceptance of the second negotiated plea agreement was confirmed by the sentencing court's December 28, 2022 final disposition, which excerpted and revised certain language from the first negotiated plea agreement signed on December 28, 2022. So remember, we took a deeper look at that, and maybe they'll get into it below. But the final disposition hodgepodged language, even though it was changed orally, it still went back to some of the old language in the first negotiated plea agreement. So, could the defendant knowingly know what they were agreeing to if it keeps changing? And I highly doubt, because the hearing was done. This final disposition was prepared outside of MOUNK TOUNK's presence, not during a hearing. So if there's a change happening after all of that, how could the defendant know? How could the defendant know? So, the sentencing court, in its oral pronouncement of the sentence, referred to the charge as possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. So, likewise, the final disposition entered by the sentencing court also lists count 30 as possession of a firearm by a convicted felon. 16-11-131B. Mr. Sledge's final plea agreement contained a condition which required him to testify at trial. After Mr. Sledge testified during the first trial on this reindictment, the state filed a motion and petition to revoke his probation. In the motion, Assistant District Attorney Adam Abate, who we're going to call ADA Abate, stated that Mr. Sledge pleaded guilty to conspiracy to violate the Racketeer Influence and Corrupt Organizations Act and possession of a firearm by a convicted felon. That's it. Period. That's it. At the evidentiary hearing regarding the motion and petition to revoke, the court took judicial notice of Mr. Sledge's testimony from trial and ruled that Mr. Sledge has violated the special conditions of probation as alleged in the petition for revocation. So, Page makes his finding, Whitaker makes his finding. He violated the special conditions as alleged in the petition for revocation. And I'm sure they're going to tell us, but we looked at that petition for revocation, and there wasn't an allegation of a specific special condition that was violated. So, The court then revoked 5 years of Mr. Sledge's 30-year sentence and ordered that he be reinstated on probation upon release. On April 23rd, 2025, Mr. Sledge filed his motion to vacate void sentence. That was the first major thing that we saw happen. On April 28th, 2025, without hearing or response from the state, the court issued its order granting defendant's motion to vacate void sentence on count 30. The court concurrently entered an amended final disposition. Specifically, on page 2 of the amended disposition, the court placed an asterisk referring to the total 20-year sentence, which clarified that the 20-year sentence was to be probated, quote, aside from the first 5 years that have previously been revoked on October 18th, 2024. Now, we got a footnote. We got our first footnote. The court's vacatur order uses the first 5 years language 3 times, including in the final sentence, which reads, with emphasis added, defendant's request to vacate his October 18th, 2024 revocation of the first 5 years of his probation is denied. On May 28th, 2025, appellant timely filed its notice of appeal in the Superior Court of Fulton County. And that was the day we just like celebrated, right? We just had like the notice and we were just like, yay! And then we had to wait for this brief. On August 12th, 2025, this case was docketed by this court. On June 30th, 2025, appellant filed a motion to vacate void sentence. Now, this is back at the trial level, this motion to vacate void sentence. So this is the appeal, the Court of Appeals, what we're looking at right now. This June 30th was at the trial court level. Due to the filed notice of appeal, this filing was improper and was unheard by the lower court. So let's get into the arguments. We've got all of that background. And I mean, I think this is a good update because it's motion. This is extremely hard work of Tiffany Adams and JamesRobichaud who are doing this pro bono. And I think, Trikisha, thank you for sharing. It's also in the description, you guys. But the link to the GoFundMe to help support Jim's pro bono post-conviction work to cover the expenses of the documents, you know, ordering all the transcripts and different paperwork is a monster on its own. It adds up really, really quickly, especially when things are pages and pages and pages and pages long. So thank you, Trikisha, for dropping that. It's also in the description. But this to me is good news because it's motion. You've got 2 attorneys that are out here fighting for, you know, not just, I think, what happened to MOUNK TOUNK, but it's also exposing all these little things that just seem careless, maybe intentional, that probably aren't the only time that this type of thing happens and goes under the radar if people aren't taking the time out of their own, you know, interest and passion for advocacy to look at it. Like, I'm sure, I don't know how many hours went into preparing this. If you asked me to write 70 pages as a first draft without thinking about doing it well, it would still take me a long time just to spit out 70 pages. But to do something well with legal writing and the proper formatting and all the research that's required to do something like this, I mean, this is weeks and weeks and weeks and weeks of like dedication from the 2 of them, which is just awesome. And hopefully what they're pointing out, because it's my opinion that there's gamesmanship happening in Fulton County with the way that they use plea deals and play with the sentencing and try to hold something, they over-sentence, the whole thing's over your head, that way you'll be more inclined to take a plea deal. Well, if you're not coloring within the lines, hopefully the appeals court can and will do something about it. And that can poke a hole in the games that the state tries to play. That's what I'm hopeful for. And also hopeful that MOUNK TOUNK, that they hear this quickly and we get a response. Shannon Boo, good to see you. Says, good morning, K&W and gang. Enjoy your hump day. Heck yeah. Mike. And FFS with the full name says, 313 people and 82 likes is crazy. Come on, chat. Yes, hit those thumbs up. Good to see you, FFS. And then let's see. Yeah, transcript fund. I should just call it transcript fund. I keep calling it post-conviction research, and then I blather on what to title it. But that. And this is, when did they say it was docketed? On August 12th, it was docketed. So, where was I? Did I scroll a lot? Yeah, I scrolled too much. Okay, we're here. We're the summary of argument. Thank goodness we had a header to find. So, 1, the trial court erred by not vacating appellant's entire sentence due to the void sentence on count 30 because the entire sentence was a package deal. Now, we've read these arguments in the motion to the trial court, but I love the argument. I think it's nonsensical to come to any other conclusion that the only way I can see this is as a package deal. I'm a layperson. I'm not an attorney. I'm not a judge in any of these courts, but just common sense screams to me that the way this deal was presented to Sledge was as a package, especially when we had the administrative assistant and Glanville. Oh, how do we keep this package together? We can't do it this way. If we want to keep these things together, we've got to do it another way. All of that, everything points to it being a package. So Mr. Sledge entered a guilty plea in the underlying case to both counts 1 and 30 pursuant to a negotiated plea agreement. The trial court subsequently found the sentence on count 30 to be illegal and vacated that sentence, but did not vacate the sentence on count 1. Given that Mr. Sledge's guilty pleas to both counts 1 and 30 were entered pursuant to a package deal plea agreement that resolved both counts, the trial court should have vacated the sentence on both counts. So 2, the trial court erred by improperly increasing the appellant's sentence on count 1 in violation of the double jeopardy clause of the Fifth Amendment. After vacating the illegal sentence on count 30, the trial court prepared and entered a new final disposition sentencing sheet. In addition to modifying the illegal sentence on count 30, the amended final disposition also effectively delayed the commencement of the 15-year sentence on count 1 from December 28, 2022 to April 28, 2025. We have a footnote that says that this summary simplifies the timeline by ignoring the period of pretrial incarceration, which, 6 to 8 months or so for MOUNK TOUNK. In other words, the 15-year sentence restarted on April 28, 2025, after over 2 years had already been served, effectively increasing a 15-year sentence to a more than 17-year sentence. Such an increase of a sentence already being served is contrary to the prohibition against double jeopardy, requiring vacatur of the sentence on count 1. The trial court erred by resentencing appellant in his absence, in violation of his right to be present at all critical stages of the proceedings against him. And to me, this is just crazy. Like, I just don't see how a judge treated this like it was no big deal. I don't know. Like, I get that she thought that she was just writing stuff on paper, but to me, sentencing, like, think about when we're watching live trials, you guys, and sentencing is about to go down. We always have to wait. We have to wait for everybody to, it's a important stage to all parties. So just because it's resentencing, I don't get how that vibe just suddenly changes. Oh, this isn't an important stage of the process. I can just write something on paper and who cares if anybody's here for it. So I just don't see how this happened, and I don't see how this appeals court will think that that's okay. So we'll see what they say. The trial court entered the above referenced new final disposition without holding a hearing, which denied Mr. Sledge his right to be present at all critical stages of his prosecution. Given that no hearing was held, counsel was also not present, resulting in Mr. Sledge also being denied his right to counsel. Of course, since no hearing was held, the new sentence was not pronounced in open court as required. These procedural defects require vacatur of Mr. Sledge's sentences. The trial court erred in accepting appellant's guilty plea, which was neither this is argument 4. The trial court erred in accepting appellant's guilty plea, which was neither voluntary nor knowing, in violation of Mr. Sledge's right to due process and Uniform Superior Court Rule 33.7. During Mr. Sledge's plea hearing, the state alternated between stating that count 30 charged a violation of 131 and 133, an inconsistency also present in the operative indictment. And this is parentheses here. The trial court's entry of an illegal sentence apparently also resulted from this confusion. As both the state and the trial court failed to consistently state the charges, Mr. Sledge could not have possibly understood the nature of the charges he was facing. And I think this is a beautiful parenthetical. The state was confused. The trial court was obviously confused because the trial court made that mistake and they admitted the mistake. They vacated that part of the sentence, and now we're taking issue with how the resentencing went down. But the trial court agreed, oops, the way the time frame of this sentencing when we revoked the probation, we messed up. The timetables don't work. But we were confused because of this. Beautiful, beautiful layout for this argument here. If the state and the trial court both failed to consistently state the charges, how could the defendant, how could Mr. Sledge, how could a layperson, any person, possibly have understood the nature of the charges he was facing? This to me is just such a beautiful layout. Right there, what is it, 3 sentences? Because due process requires defendants to understand the charges they face before entering a guilty plea, Mr. Sledge's guilty pleas were contrary to due process and must be vacated. So 5. The trial court failed to advise appellant of his right to withdraw his guilty plea when the trial court rejected the first negotiated plea agreement as required by Uniform Superior Court Rule 3310. Thus, his conviction must be reversed. The trial court rejected the first negotiated plea agreement by and between Mr. Sledge and the state, stating, "You just can't do it this way," and permitting the parties to negotiate new terms. They did so, and Mr. Sledge's, parentheses, defective, guilty plea, tell him, was entered shortly thereafter. However, the court did not, as it was required, inform Mr. Sledge that he had the right to withdraw his guilty plea as a result of such rejection. Georgia courts apply a bright line rule to this requirement. Accordingly, Mr. Sledge's guilty pleas were defective, and the consequent convictions must be vacated. Does bright line mean it's not a gray line, like it's very clear? Let me see. Providing an unambiguous criterion or guideline, especially in law. So the opposite of it's a gray area, it's a gray line. It's very clear that this is defined, well defined, it's not ambiguous. There's no room to wiggle wobble on this here. So accordingly, these pleas are defective and the consequent convictions must be vacated. So, cool. I've never really heard the term bright line used, but it was easy to infer the meaning because of the usage there. 6, we're going to argument 6. The trial court's revocation of 5 years of appellant's probation constitutes an illegal sentence because appellant's underlying sentence did not contain any special conditions of probation. The state's petition to revoke appellant's probation did not allege the violation of any specific special condition of probation, and the trial court did not find that appellant violated any specific special condition of probation. And this is where we get into Adam Abate messing up, because remember, he wrote the motion to petition for the revocation. He wrote the petition. He was also in the hearing. Love didn't want to be present. Remember, she showed up in like the leather jacket at the end. During the hearing, Abate was like, whatever the court decides is fine. And then Whitaker just said, oh, okay, the state alleged something. I agree. Before a trial court may revoke any portion of a probationer's probated sentence, due process requires that the state inform the probationer of the violations alleged and, at a hearing, prove those violations as alleged. Now, this is important because they have to prove at the hearing that the violations were alleged. But we saw that Whitaker just, hey, they filed this petition and yep, the petition's fine. Revocations in excess of 2 years must be predicated upon the violation of a special condition of probation or the commission of a new felony. Here, the state's petition to revoke Mr. Sledge's probation vaguely alluded to violations of special conditions of probation, but did not actually identify any specific special conditions. If we don't get into case law here, you guys, I think that might follow below, where they go through all the different case law. If you're not going to stick around for the case law stuff, there's tons of case law that says it must be a specific, you have to specify which special term was violated. all the case law supports that it cannot be vague. It cannot be ambiguous. It has to be explicit. So just throwing that out there in case you guys don't make it, because we're only on page 25. And obviously, if you want to go revisit the motion to vacate that was filed in June, there's a link to that in the description, a stream on that. That's covered in depth as well. But because the petition did not contain any allegations, just start using this for all the effects, all of these little spicy bits, either general or special. The trial court's revocation of 5 years of Mr. Sledge's probation violated due process and constitutes an illegal sentence. Accordingly, the court should vacate the revocation of Mr. Sledge's probation. So let's see. We need a sigh counter. Oh man. It's like I think about it and then I don't think about it. But once I start thinking about sighing, I can't not think about it. Heck yeah. Free MOUNK TOUNK. Ooh, so good to see you, B North. B North says, I think his attorney messed up too, and that should be a huge factor. So this is the first filing. You know, we're at the appeals court here. In those motions to the trial court, we didn't see anything about ineffective assistance of counsel, but here in this appellate brief, we finally have IEC as an argument coming in. And we should be getting to that. I think that was like argument 9. So we're 2 arguments away from that. But a lot of people have been waiting for that, and we finally got it here. Let's see. It sounds like thunder. I've got to get the little... Where did I put my stream deck? I've got to set it up. I think if you guys were present like a few streams ago, I was like, a while ago, like over a year ago now, my second monitor burnt out. And I had 2 of the same monitors. And I still haven't reordered a second monitor because I just don't want to make a decision on what monitor to order. It's like too many choices. I'm a creature of habit. I like sticking with the same things. But I've had these monitors for a while. And because the one burned out, I'm like, well, maybe I don't want to order the same one. So I've still got to go and do that. But once I finally commit, I have ordering commitment issues to a second monitor. I'll get my little stream deck set up and we'll have a fair amount of fun sound effects when we have a spicy footnote, things like that. Nothing too crazy during serious trial moments. But I'm waiting for there to be like a hurricane myself, and if I accidentally hit the button and do that boom, if I'm going to think that there's like bad weather happening near me, even though it's my button. Good to see you, Distance to be. Yes, let me reshare this. Simply AMAC is this document. Let me get you the link. And I think this shares... StreamYard says that this filing comment that I'm dropping in the chat is going to Twitch as well. So you guys can pull it up and read along. And I think it's searchable. I think they made it searchable. Let me see. We're on page 26. Let's try and notice. Yeah, it's searchable. Love it. So really helpful to have handy to go look through and find things. And then let's see. I think we were here. We were on argument 7. So the trial court erred by taking judicial notice of appellant's trial testimony during the probation revocation hearing. Before taking judicial notice, trial courts are obligated to provide parties with an opportunity to object. Among other things, and North, I think this is where we're going to get into, this might be a overlapping argument. Among other things, this rule helps maintain a clear record of the evidence entered during a given proceeding, which facilitates appellate review. All of the evidence relied upon by the trial court in revoking Mr. Sledge's probation came in by way of an improper judicial notice, as the trial court did not provide the parties with an opportunity to object. Accordingly, the court should vacate the revocation of Mr. Sledge's probation. And I'm actually curious for like the case law part about this. Is this something, the way I'm reading this and the way this is worded, and I feel like I've gotten pretty used to Tiffany and Jim's writing, I feel like they're wording this because there's case law that says the trial court must explicitly say any objections. Like they have to pause and take a moment to ask the parties before they continue on, before they proceed. So we'll see if there's some case law, because that's how I'm interpreting this wording as we're reading it right here. So accordingly, the court should vacate the revocation of Mr. Sledge's probation. Now we're going to get into, and it is going to overlap, I'm sure, we have ineffective assistance of counsel. So argument 8, appellant received ineffective assistance of counsel during plea negotiations and sentencing. So Mr. Sledge's trial counsel signed off on his entering into a plea agreement, which provided for the entry of a sentence pursuant to 133, which carries a 15-year mandatory consecutive sentence, the elements of which were not alleged in the operative indictment. Mr. Sledge was actually charged with 131, which would have carried a 5-year sentence that could be run consecutively. This is a great argument. In other words, Mr. Sledge's counsel signed off on a sentence at least 3 times the length of the correct sentence. Such patently ineffective... Oh, we're going to do patently ineffective assistance of counsel demands vacatur of Mr. Sledge's conviction. And the point is I feel like there might be an inclination to look at this and say, well, so they all agreed to something that was worse, and we find out that it's really something better for Sledge. It's really something better. So what's the harm? Well, the harm is if you're making a decision whether or not to take a plea deal or take something to trial, and you think that this is what you could be facing, and if you go to trial, you might not have the opportunity to negotiate that this will be served on probation. We're going to say, Judge, we've agreed that probation's fine. We're going to withhold the sentencing until after sentence on count 1 is served. If you think you have this maximum timetable, 3 times the length, consecutive, can't be served concurrently, hanging over your head, that could be the decision maker, what makes or breaks your decision to take a plea at all. And it's not fair, it's not informed, it's not knowing for you to make your decision based on that context when the context is totally different. So sure, cool. Oh good, it's actually less, what a good mistake. Well, no, not really, because we could have gone down a whole different path if we had different information. So, let's see. 9, appellant received ineffective assistance of counsel when counsel failed to object. So we're going back to argument 7, but now we're approaching it instead of the court erring by not asking the party if they had any objections and just making an improper judicial notice. Now we're going to say it's also ineffective assistance of counsel because we're missing certain objections, specifically to false criminal history that was being read into the record by the unsworn witness from the probation office. During Mr. Sledge's probation revocation hearing, an officer from the Department of Community Supervision testified, without being sworn, that Mr. Sledge had previously been convicted of attempted aggravated sexual battery. He has not been convicted of or even charged with attempted aggravated sexual battery. The DCS officer, we have a footnote. Oh, the footnote reads as this. The DCS officer, buttressed by improper testimony from the state. I'm going to ban myself from the boom. Because when we're dealing with Fulton County, I think the booms would be OD. It'd be overload. Also incorrectly stated that Mr. Sledge had previously been convicted of violating OCGA 16-11-131. Mr. Sledge's counsel was clearly ineffective by failing to object to these fabricated, quote, convictions. Such ineffective assistance warrants vacatur of the revocation of Mr. Sledge's probation. Oh, man. So that's our summary of the arguments, the issues. This is going to get us into the nitty-gritty of each one with the case law. I'm personally interested. I love the case law. I love that I'm learning, like Parrott v. State, Clue v. State. I'm starting to recognize the citations themselves and already know what issue we're getting into. And that's just a really cool feeling. It's like, watching sports and learning people's stats over time and learning their career history. I feel like that's what we get to do when we read these motions over and over. We're starting to really learn and it's sticking. So I like this stuff. I know a lot of people head out once they get the top level overview. So if you're going to head out without getting into the deep nitty gritty, thank you guys for still following this issue. Again, the links to Tiffany and Jim for all of their socials that I'm aware of, I think their X's and their YouTubes, are in the description of this video. So make sure you go over and follow them, support their channels, support their X accounts. You know, they talk about other issues, other cases, not just MOUNK TOUNK, but of course they're the best place to get updates on what's going on with MOUNK TOUNK as well. So they are the best people to follow. Also, there is a link to the transcript document fundraiser to help Jim offset the costs and expenses of all of the procurement he's got to do for the other cases he's looking at. Largely Fulton County cases, but there are some cases that fall outside of Fulton County. But if you want to see him keep doing that work, it's a great way to support him in his efforts there. So FFS is over on Twitch. So guys, I only used to do Twitch as for gaming. And I explained a little bit yesterday, but the main feature is if someone wants to watch trials with me, enjoys my commentary, appreciate anyone saying that, but doesn't want the ad interruptions, doesn't like when YouTube interrupts. Twitch has ads as well. Twitch will interrupt, but there's a feature on Twitch where you can use your Amazon Prime subscription. If you use Amazon Prime, you can use it to subscribe to a Twitch channel. And over on Twitch, subscriptions are the memberships. And when you're a paid member of a channel, you don't get ad interruptions. That's a really cool feature of being a member of a channel that YouTube, if you're a member over here, you get to support my channel. Thank you so much. You get emojis, and you get some perks that are really the decision of the creator. It's like a fun little thing to do. But YouTube doesn't give you this perk of skipping ads just because you are a member of a channel. Twitch, if you are a paid member of a channel, you can skip their ads. So Twitch has a different feature that I thought could be helpful for people that don't like to get those interruptions mid-trial and have to deal with the ads. But after thinking about that, Twitch has so many other features that I think are really cool. There's different ways that you guys as a chat, I can interact with you on streams where, and I've got to learn a bit more how to do it. I think it might require, I might have to go to AI and help me do some novel generative work, but there's ways that you guys as a chat, and I really want to learn how to do it. I really want to learn how to do it. Is like I could pick random 3 people from the chat. So let's say we take Bray, we take Bye Bye Bunny, and we take that guy Nick, and I'm like, okay, we're gonna have role play 3 jurors. I've watched creators do things where they assign a generative AI voice. They'll pick random people from the chat, and I can put up like 3 little avatars to represent them on the bottom of the screen. And they'll do like roleplay, like Dungeons and Dragons type of stuff with it. But I was thinking, like, wouldn't it be cool if we could do mock jurors? And we could just have randoms from the chat. Maybe we make them anonymous, but they could make their face red or green depending on whether they're feeling guilty or not guilty. There's just so many applications with what's going on with Twitch. Like, my mind was racing with ideas. So I figured I might as well start now, launch the channel, have you guys over there. Thank you guys that are watching over there, because you're going to help me unlock access to some of the features that when you first create a Twitch, it'll tell you you have to wait till you're an affiliate to be able to use things. But I don't know. There's just so much cool stuff that I think we can do. But I don't know. I got to figure it out. I've watched a lot of it. I got to learn how to do it on the back end. But I'm just so excited. So we'll see. Nick seems down for the idea of being a mock juror. All things like that. There's tons of ideas. Things that we see the creators do in the gaming space. There's so many applications for, you know, reacting to motions, trials, and other types of stories. So super, super, super excited here for a little bit of the bridge over to Twitch. Yeah, Jersey Girl Trey with the Twitch emoji. So the Viverito bush, I looked this morning, it still says it's pending. It, like, Twitch didn't approve the Viverito bush icon. So that's why that emoji is not over there. But I think some of the other ones were approved. I put MOUNK TOUNKs on there this morning and it was approved right away. You guys should be able to use that. And there should be a tier. I went and looked again. There should be a tier. There should be a SpongeBob one. If you guys can use the SpongeBob one, you don't need to pay to use that one. I can make 3 emojis special to the channel that everybody can use without paying, which is something that you cannot do on YouTube. I wish YouTube would give us a few free emojis that everybody could use without having to pay. But so let's see. Also, Creed here says, I'm glad this appeal was filed. I hope Antonio gets the right result and clears the Sledge name. Me too, me too, me too. Oh, Bailey still can't link accounts. I think that might be an Amazon Prime being butt cheeks. I don't think I haven't seen an appeal filed, but I think they have 30 days. So you guys know the state and their homework. They're going to file that on the 29th day at the final hour. Probably. So we'll see. They still have time. But I have not seen it yet. So if they have already, I just haven't seen it. Let's see. Okay, yes. And there we go. So, Bailey's, it looks like the free emojis are working. The 3rd one is the Viverito bush. It's just not, they won't approve it. Twitch is taking issue with me having Viverito in the bushes. Oh, boy. With that being said, let's get back over here to these arguments. Thank you for my Twitch spiel, guys. I'm really, really, really excited about that. I have no idea what I'm going to do yet, but I think it'll just be a fun way to spice it up. And there's not much. I tried looking for tags that relate to like legal stuff, like trial watches, and I don't really see that over on Twitch, but we're going to find a way to bring those features to life in this genre, this topic. Yeah, Trakisha has the got him. So let's deep dive. We've got argument 1. Again, this was the count 30. The sentence should have been voided entirely because count 1 and count 30 together were this package deal. So the court ruled on April 28th, 2025, that Mr. Sledge was correct and that the sentence on count 30 was void. The court's amended disposition implemented the vacator of the original sentence on count 30 and detailed the resentencing on that count. The trial court, however, failed to rule on the argument that the plea entered on count 1 and count 30 was a package deal, and since the sentence was void on count 30, it was void as to the entire sentence, and the entire sentence should thus be vacated. A trial court's reformation of a void sentence is reviewed under the abuse of discretion standards. So that's under Parrott v. State. So let's get into the sub-argument here that sentencing courts generally enjoy broad discretion in resentencing partially void sentences. And again, this might seem a bit of a repeat because they did get into this case law in the motion to the trial court that we read previously. To me, I like to reinforce it, and I'm sure there's people that didn't hear it a first time, so we're going to read it again. The Georgia Supreme Court acknowledges that its handling of the sentences that could be characterized as partially void may appear to be inconsistent. That's Parrott v. State. In some cases where only a portion of a sentence, such a parole condition, was found to be unlawful, the court vacated only that specific condition. In other substantially similar cases, the Supreme Court has vacated an entire sentence and remanded for sentencing. So there's a range of things that you could do. Far from inconsistent, pertinent precedent illuminates twin maxims. 1, that trial courts are generally afforded broad discretion in resentencing, and 2, trial courts are not required to adopt a single exclusive method for exercising that discretion. Accordingly, sentencing courts have vacated the entirety of a partly void sentence in a variety of contexts. So they've got Parrott v. State, which also collects other cases. They've got Kaiser v. State and Jackson v. State cited here. In Parrott, the Supreme Court specifically expressed no opinion as to whether the trial court could also resentence on other counts, for which the sentences are not void, to preserve an overall sentencing scheme. Notably, the Supreme Court took the time to explicitly clarify that 2 prior cases, Ellison v. State and Humphrey v. State, in which the court ordered only the void portion of a sentence stricken, merely emphasized which part of a sentence on a particular count the trial court was required to vacate, as opposed to limiting the trial court's sentencing discretion on remand. In Clue, the trial court determined that Clue I always think it's so cool somebody's name is Clue. What a cool last name. The defendant had received ineffective assistance of counsel during plea agreement negotiations, but only as to 4 of the 6 convicted counts. Clue subsequently filed a timely motion to withdraw his guilty plea, which was granted as to the same 4 counts and denied as to the remaining 2. We have a footnote that reads, while Clue differs from the instant case with respect to procedural posture, it has repeatedly been cited in cases concerning partly void sentences. The Court of Appeals held that the denial constituted an abuse of discretion because 1, the ineffective assistance as to the 4 counts undermined the voluntariness of Clue's plea to the remaining 2 counts, and 2, the defendant's negotiated plea agreement was a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. Now, if you ask me, layperson over here, this is setting up a nice tea because we're seeing them bring in this argument of ineffective assistance of counsel during, the December 2022 plea hearing and the confusion over what we're actually agreeing to. We've tied in that the court agreed that all of that was wrong. The state had it wrong. Obviously, the defense attorney agreeing to it is presumably wrong. And then the revocation, we took into consideration the wrong sentencing timetable, so we were wrong with that too. So I think they teed up. I would imagine if I'm picking up what I think Tiffany and Jim are putting together, all the marbles, or putting all the marbles in the ring, I would imagine these appeals court judges would see what they're getting at. Let's see. In Kaiser 1, Kaiser the First, a physician entered into a negotiated plea agreement. Pursuant to a negotiated plea agreement, Kaiser pled guilty to more than 60 counts and received a 30-year sentence. At the plea hearing, the sentencing court, sua sponte, that means the court does it on their own. The judge, without being asked or moved by both or either party, just on their own, altered a negotiated special condition of probation, rendering sentence indeterminate and therefore void. Treating the negotiated plea agreement as a package deal, the Court of Appeals vacated the entire sentence and remanded for sentencing. In so holding, the court observed that, in many circumstances, it is appropriate to view the final negotiated plea agreement as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. Single void, and this is Halford, they're also adding in this holding that a single void special condition appropriately stricken, where plea agreement left all conditions of probation in the discretion of the sentencing court. So B, the adopted plea agreement was based on a shared misunderstanding. So there we go. This is the marbles. They're bringing all the marbles together. The adopted plea agreement was based on a shared misunderstanding that count 30 charged 133. Sentences imposed pursuant to 133 must be for a term of 15 years and must be run consecutively to all other sentences. 133B. Mr. Sledge was led to believe that count 30 charged 133. Thus, he sensibly and successfully negotiated for concessions with respect to count 30 as if it charged 133. He secured a promise that count 30 would be null prost, that the sentence could be suspended, and that the sentence could be served on probation. From Mr. Sledge's perspective, those were the most critical points of the plea negotiations. This is why I'm willing to take this plea and not take it to trial. That count 30, in fact, charges 131, renders the concessions that he negotiated pointless. Oh my god, he put it in here! Jim! He did it!
Your point is pointless.
P for pointless. Section OCGA 131 carries a maximum sentence of either 5 or 10 years, depending on whether the defendant has previously been convicted of violating 131 and can be run concurrent with other sentences. I think we're going to hear more about this. Thus, had Mr. Sledge known the true charges and the corresponding sentences, he could have approached negotiations entirely differently. Accordingly, like in Clue, where the ineffective assistance undermined the voluntariness of Clue's guilty plea, here, the flaws in the re-indictment undermine the voluntariness of Mr. Sledge's guilty pleas to both counts 1 and 30. Accordingly, the court should treat the sentence as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. And again, some of this, not the ineffective assistance of counsel, But some of this was raised to Whitaker at the trial court level. And that's, remember me saying at the beginning of this stream, she made this a sentence. Oh, we'll just move the sentencing over here. Oh, that one's void, but we'll just put those years over on count 1 and we'll wrap it up with a bow and ship it right back out without holding a hearing. She didn't address this issue. She didn't make any writing. She didn't argue about why she was or was not viewing this as a package deal. She just ignored the argument. And I think this is a huge and critical argument. I think even though there's discretion, I think all things considered, the context here, I think it's inextricably a package deal. So this is just one of my favorite arguments. It was one of my favorite arguments before they introduced the ineffective assistance of counsel, now that we're dealing with the appeals court. But that ineffective assistance of counsel obviously adds like the final layer, right? So thus, the court should find Mr. Sledge's entire sentence void and vacate it. See, the conditions of probation are applicable to both counts 1 and 30, confirming that Mr. Sledge's adopted plea agreement was a package deal. There is no doubt that the second negotiated plea agreement that Mr. Sledge was sentenced to was a package deal, as was the first negotiated plea agreement signed on December 28, 2022. As reflected in the original disposition, the second negotiated plea agreement provided that Mr. Sledge, upon meeting certain special conditions of sentence, would be permitted to withdraw his plea to count 30 and have that count dismissed. So, the terms were dependent. The terms made the term of count 1 or count 30 were dependent on how Sledge followed the terms of count 1. How could that not be considered a package? How could you say they're separate? Thus, the original disposition specifically contemplated the conditions applying to count 1 alone, or to both counts 1 and 30. Such conditions would govern the sentence on count 1. Were Mr. Sledge to serve the count 30's sentence, he would do so under the very same conditions. The sentences on counts 1 and 30, though consecutive, are structurally indivisible. Sentencing on both counts was done in tandem and cannot be separated. The state treated the sentences as a package deal when it was in the state's interest to do so. Mr. Sledge has consistently accepted the state's characterization, and the state should be held to that position. Accordingly, the court should vacate both sentences. So, if the state wants to treat it as a package deal, they can't change their mind now when there's an issue with treating it as a package deal that would favor the defendant's position. All right, next argument. So the trial court erred by improperly increasing the appellant's sentence on count 1 in violation of the double jeopardy clause of the Fifth Amendment. And I think this is going to be some new stuff a little bit here, I think. Let's see. Once a person has entered upon the execution of his sentence, the court is without power to change it by increasing the punishment. And that's Pitts v. State. This is because in the multiple punishment context, the double jeopardy clause of the Fifth Amendment protects a defendant's legitimate expectation of finality in his original sentence. They got Parrott v. State and Maddox v. State, Pittman. The legality of a given sentence is a matter of statutory interpretation, subject to de novo review. Here, the amended disposition entered upon resentencing imposed upon Mr. Sledge a 20-year probated sentence. Then we're getting the quote. Aside from the first 5 years that have been previously revoked on October 18th, 2024. Thus, the revoked 5 years are the first 5 years of the 20-year sentence. The revoked 5-year sentence and the full 20-year sentence began to run on October 18th, 2024. Prior to the amended disposition, count 1's 15-year sentence was to run from December 28th, 2022 through December 27th, 2037. As a result of and it's like, nobody seems to like doing sentencing math, but it's like they really just didn't give a F when they resentenced MOUNK TOUNK. They're just like, I literally am thinking of that SpongeBob episode where they have like this giant worm that's taunting and causing issues with Bikini Bottom, and they have a town hall meeting, and Patrick Star is like, I have an idea. Why don't we just take Bikini Bottom and push it over there? And he thinks if we can just move the whole town to another spot, the problem goes away. And that's what I feel like Whitaker did with this 5-year revocation. We'll just, sentence for count 30 is void. We'll just drop it over here to a different sentence for a different count. And then we'll also say that it's not a package deal. So we're using it interchangeably to move the years of the sentence around, but not to consider it the whole thing void. Anyway, as a result of the amended final disposition, count 1 is to run from October 18th, 2024 through October 17th, 2039. In sum, the amended final disposition extended the sentence by nearly 2 years, from December 27th, 2037 to October 17th, 2039. Yeah, that's a no bueno. That's a no bueno. Harris v. State is instructive. In Harris, the defendants were convicted of and sentenced on 2 counts of armed robbery. The defendants subsequently moved to vacate those sentences, arguing that the 2 counts should have merged. The state conceded the point, and the trial court resultantly vacated one of the 2 sentences. However, the court simultaneously increased the term of the sentence of the remaining count from 10 to 20 years. So we've got a similarity here, right? Different math, but we get rid of one thing, we just increase something over there. On appeal, the Court of Appeals held that while a trial court can correct a void sentence at any time, it generally cannot increase a valid sentence once a defendant has begun serving that sentence. So this is such a catch-22. You're trying to maintain that count 1 is valid, that it's not void as a package deal because you ignored that argument entirely. Whitaker did not address that argument. But since you're saying that it's still valid, you can't just go and increase it. Oops. As the defendant's original sentence on the remaining count was legal, and the defendants had already begun serving that sentence, the double jeopardy clause prohibited the resentencing. Accordingly, the Court of Appeals vacated the amended sentence and remanded. Here as in Harris, Mr. Sledge was sentenced on 2 counts, one of which was subsequently vacated, and one of which he continued to serve. The court increased the term of the sentence imposed on the court Mr. Sledge had been serving for years, count 1, when it vacated the void sentence, count 30. The result reached in Harris, and I think, if I'm not mistaken, I know one of the major things that, we've learned to be one of Jim's pet peeves is the 131 versus 133 issue and how Fulton County consistently gets it wrong. Maybe on purpose, who knows. But another thing that Jim noticed very, very early on is that the sentencing was supposed to be withheld and that he'd be able to withdraw at a later time. And I think, and again, Jim's coming from the civil litigation world, and seeing the way that this was written out pissed him off. Well, this was back in like October, December. He was like screaming in the chat. He'd be yelling in all caps in the chat. We only knew him as Jim R back then. He didn't have Happily Angry Lawyer. He finally made a Twitter account around that time. Ended up making a YouTube channel earlier this year. But he was peeved. Something was under his skin about the term of how, okay, we're going to withhold sentence. He's allowed to, withdraw, and we're going to withhold sentencing. And I think we're finally seeing, like, this super pet peeve of Jim. Like, he finally, like, put it all together on paper. Yeah, he was going off. So here is in Harris, Mr. Sledge was sentenced on 2 counts, right? Let's digest this. One of which was subsequently vacated, and one of which he continued to serve. The court increased the term of the sentence imposed on the count Mr. Sledge had been serving for years. Count 1, he's serving that RICO count. When it vacated the void sentence, count 30. The result reached in Harris, vacator of the Harshen sentence, is the correct result here. This court should vacate the sentence on count 1, which is void, as violative of the double jeopardy clause. Whew. The trial court erred by resentencing appellant in his absence, in violation of his right to be present at all critical stages of the proceedings against him. A criminal defendant has the right to be present during all portions of his or her trial, and a defendant's absence during a critical stage of those proceedings, absent a waiver of the defendant's right to be present, is not subject to harmless error analysis. And I think harmless error was like, put a 1 in the chat if you like tingle a little bit when you hear harmless error, because there's always like this underlying, are they just gonna say, yeah, they messed up, but it was a harmless error? And then yesterday, I think we finally looked at an exoneration where a court finally said the error was not harmless. And it was kind of like, whoa, that's rare. That's really rare to hear. Now, let me look over here. For Always Forever Life says, I love Happily Angry Lawyer's passion. Me too. Me too. I always wonder, you know, like, if he was writing these motions on his own, or seeing him argue, like, if he goes in person, if there's a hearing, and I actually want to go. So Atlanta's like it's like a 7-hour drive. The last time I went up to Atlanta, there were so many accidents. It took me 14 hours because I was just stuck 2 separate times in like completely stalled traffic. It was horrible. But on a good day, it's like a 7.5-hour drive. I would love to go see, and obviously Tiffany too, but I can just picture Jim in court being hilarious. And I mean that with love. I mean that in the most positive way. Just being hilarious to watch. But lots of ones. Yeah, that harmless error. So harmful error is like, they'll decide it's not harmless, thus it's harmful error. It erodes confidence in the outcome of the case or trial or whatever adjudication. Oh, is it not? Yeah, let me redrop the Twitch link, you guys. Twitch. Oh god, that was a really long link. It probably broke. I think the URL was too long. All right, so if you guys want to hop over on Twitch, let me just share this to YouTube. There's a link in the chat. That one should actually work. Hopefully. Thank you, YP Chic. Purple looks good on ya. Yeah, for Always Forever Life is 7 hours. I couldn't do it. I think that's like I can do that in one shot, maybe stop once. And we have a Buc-ee's on the way now, so it seems like I can't not stop, right? You gotta go to Buc-ee's. We didn't used to have a Buc-ee's on the way, now we do. So 7 hours, one stop. One stop. B North. Not a new one. And we can plan something. We can still plan something. I'm sorry if I've been ignoring you. It's not intentional. It's just the idea of planning some new thing when I really only pop on when I see a sudden story and jump on. I'm not really good at things. But we can still plan something for sure. I'm in Florida, so I'm in Brevard County. So if there's no traffic, I mean, I can just hop on the highway and it's pretty much a straight shot up to Atlanta. But if I get caught between exits and there's an accident, it adds like 2 hours. Oh, man. Yeah, it's that one. I think it's that Buc-ee's, KP. I think they're opening another one. Because there's one in like Daytona and then there's one in somewhere else. And I think Buc-ee's are expanding. They're moving everywhere. They're coming for you. But back over here, we've got the standard of review. I read this, right? Because this was highlighted. Okay, yeah. So the defendant has the right to be present during all portions of his or her trial, and a defendant's absence during a critical stage of those proceedings, absent a waiver of the defendant's right to be present, is not subject to the harmless error analysis. So it is. it is harmful. The standard of review is abuse of discretion of the trial court's decision to resentence the appellant in his absence. And they're citing here Dunn v. State. Trial courts are obligated, there's no discretion, to permit defendants to be present for their resentencing proceedings and must issue the amended sentence in open court. Thus, where a defendant is resentenced or a sentence is amended, the defendant should be allowed to be present. That is because a resentencing proceeding is a critical stage in which a defendant's rights may be lost, privileges may be claimed or waived, or in which the outcome of the case can be substantially affected. And I think that's an issue here. Violations of a defendant's right to be present at all resentencing proceedings are presumed prejudicial and are not subject to harmless error review. It just is. That's Taylor v. State. Proceedings within the ambit of the right to be present include both resentencing hearings and pronouncements of amended sentences, which must be made in open court. In Pittman, the trial court held a resentencing hearing attended by the defendant, with counsel present. However, the trial court did not issue its amended sentence in open court. Now, here we're getting a case where there's a little bit of difference in the context. But in Pittman, the context is more favorable. The additional context that Pittman has that's, more helpful to maybe going to fix the court's error is absent in MOUNK TOUNK's situation. But even just this little bit, the trial court, so the defendant and counsel were present during the hearing, but the trial court issued the sentence outside of court. This is the one similarity. We're missing this overlap. But even just this is an issue. So the order was emailed to the parties. As such, the trial court erred. Even though they had the right to be present, and then the sentence was issued, the amended sentence was issued after, even though they were present, that was an error. It was not harmless, and accordingly the Court of Appeals vacated the sentence and remanded with instructions for the trial court to reimpose the modified sentence in open court. So, we did it wrong. You've got to go do this in open court. Similarly, in this case, the appellant was not resentenced in open court, but received a resentencing order through the court's e-file system. The sentence was not pronounced in open court as required by law. Therefore, the appellant's sentence pronounced on April 28, 2025 should be vacated. Now, if this ends up being, say the appeals court just does this issue, they ignore all the other arguments, they decline all the other arguments, they're like, no, we don't agree, but they find for this argument and we end up having a sentencing hearing, I would go. I will go. The trial court erred were an argument for. The trial court erred in accepting appellant's guilty plea, which was neither voluntary nor knowing, in violation of appellant's right to due process under the Constitution and Uniform Superior Court Rule 33.7. To properly form the basis for a judgment of conviction, a guilty plea must be voluntary, knowing, and intelligent. Kennedy v. Primack. Because a guilty plea is an admission of all the elements of a formal criminal charge, it cannot be truly voluntary unless the defendant possesses an understanding of the law in relation to the facts. Uniform Superior Court Rule 33.8a reflects the foregoing case law. So cool. So we've got it codified, this case law. And the quote here is that the judge should not accept a plea of guilty without first, A, determining on the record that the defendant understands the nature of the charges. A defendant's due process rights are violated by such defendant's entry of a guilty plea that is not voluntary, and such a guilty plea is therefore void. The standard of review is an abuse of discretion. So here, as discussed in the statement of the case above, the state repeatedly conflated 131 and 133. Mr. Sledge's counsel likewise failed to identify those errors. I'm gonna make Jim a gift. Maybe get him like a coffee mug that says 133 on one side and 133 on the other. Or like a coaster, like a drink coaster, you flip it if you want to be 133 today, 131. Something that we can switch. We gotta do something. Give something Jim with this different in 3, or 2 jerseys. Can you imagine Tiffany and Jim having jerseys and one of them says 131 and one says 133? Mr. Sledge's counsel likewise failed to identify those errors and consequently acquiesced in Mr. Sledge's plea of guilty to an offense that was not charged. The trial court also appears to have been confused as to the nature of the charges, finding that Mr. Sledge violated 131, but sentencing him pursuant to 133. In sum, none of the highly experienced attorneys who were present at the plea hearing. I mean, we are making an ineffective assistance of counsel argument about the one, but what a way to pat the shoulders of attorney love, ADA love. In sum, none of the highly experienced attorneys who were present at the plea hearing understood the nature of the charges. To attribute such an understanding to Mr. Sledge, a layman, is patently unreasonable. Indeed, Mr. Sledge entered a guilty plea to a crime that was not even alleged, and which carries a substantially harsher penalty than the crime that was actually charged. Not something done by a rational and informed defendant with an understanding of the pertinent law. Given that Mr. Sledge lacked the requisite understanding of the law in relation to the facts, the court should find that Mr. Sledge's guilty pleas were not voluntarily given and therefore void. I would love for the court to agree on this issue, because this would just be such a spike. And we saw it happen within the YSL trial, where Love wanted to play. It wasn't enough for her to read the transcript and get the witness to say, yeah, you remember the plea hearing? Yeah, I remember the plea hearing. Remember you saying that you knowingly and voluntarily agreed? Yeah, I remember that. Oh, well, we're also going to run a video so the jury can see it for a third time and really drive the point home that you made this decision knowingly and voluntarily, without being under pressure or under duress or under any type of coercion from us, the state. We do everything right and amazing. We love you. We're so nice. Love wanted to, any way she could, bolster how voluntarily and knowing these pleas were. If the Supreme Court were to agree that Sledge is right with this argument here, that is such a smack to the way Love and other prosecutors rely on the, well, you knowingly and voluntarily signed this, didn't you? It would be a beautiful smackdown. And I don't know if they're going to want to go there. And again, there's so many arguments raised here that, I don't know, they could say, since we're agreeing to do this on this ground, we're not going to address these other arguments. But I would love to see what they think there. 5. Argument 5. The trial court failed to advise appellant of his right to withdraw his guilty plea when the trial court rejected the first negotiated plea agreement as required by Uniform Superior Court Rule 3310. Thus, his conviction must be reversed. And this is stuff we looked at, I think, in the first motion at the... I think this was in one of the motions. A little bit. But again, let's just go through it. Let's learn it. Let's really get a good absorption of how this works. So, A, the applicable provisions of Superior Court Rule 3310. Pursuant to 3310, which codified the Supreme Court's holding in State v. Germany, this is where we get the Uber driver fan mail, a sentencing court that intends to reject a negotiated plea agreement must inform the defendant personally that the defendant may then withdraw his or her guilty plea as a matter of right. So, if we're going to reject this, you have an opportunity on the record to say whether you want to withdraw or not. We have Troop v. State. The steps to be taken in rejecting a plea agreement are not optional. Failure to so inform the defendant mandates a reversal of the conviction. This is that bright line. We're going to use that term. Bright line. Mandates a reversal. Failure to inform. The court's failure to inform mandates a reversal of the conviction. A trial court's compliance with Superior Court Rule 3310 is reviewed de novo. That's in Jackson v. State and a bunch of other cases. Ultimately, adherence to Superior Court Rule 3310 ensures that a rejected and subsequently withdrawn plea cannot be used against the defendant in the ensuing trial or other judicial proceeding. In other words, just because you were about to agree to a plea deal and you said you agreed, but then there was an issue and they say, nope, we can't do this. If you were to withdraw at that point, and I can imagine Love, like the same mistake she did with the Alford plea mistake, Well, you said at this hearing that you agreed to all these terms, and then having an attorney say, Your Honor, I have a motion, and then having to tell the court, this prosecutor was the one that was at that hearing. It was withdrawn. It was rejected and subsequently withdrawn. So it shouldn't be able to be used against this person. Can you picture the state messing up and doing that? Messing up. But this is really important case law. So if you withdraw, even though you acknowledged it once and said it once, you can withdraw it. And it can't be used that you at one point signed yes and agreed to a plea agreement. Such use would be fundamentally unfair to defendants who seek to accept responsibility and resolve criminal charges, would unduly chill negotiations between defendants and prosecutors, and would be contrary to well-accepted Georgia law. The court in Troop also detailed an underlying policy consideration, protecting the integrity of the adjudicative process, particularly with respect to guilty pleas. There is another reason why admissions made in connection with rejected guilty pleas should not be used against the defendant in a subsequent trial or other judicial proceeding. Specifically, in order to be admissible, confessions must be made voluntarily without being induced by another by the slightest hope of benefit or remotest fear of injury. While trial courts are certainly authorized to reject the parties' agreement, they are not authorized to use defendants' admissions made in connection with that agreement as to the basis for resentencing. The law is clear. When a sentencing court rejects a negotiated plea agreement before the defendant pleads guilty, the sentencing court must, among other things, personally inform the defendant of his right to withdraw his guilty plea. They didn't do that. So B, the sentencing court rejected the first plea agreement. A plea is considered negotiated when there is an agreement between the state and the defendant as to the sentences to be imposed. A trial court, and remember, the trial court rejected this because, and I always forget his name, but the judicial assistant, I think it was like Mr. W, something with the W maybe. Maybe not. I don't even know. I've read his name enough times that I should know it. But it's like, the judge had to be told that it was a problem, and then they're like, oh yeah, I can't do it this way. So, a whole mess of people not understanding that they were what Sledge was even agreeing to. A trial court rejects a negotiated plea agreement when, after the defendant enters his guilty plea and the negotiated sentence is presented, the court imposes a sentence other than that which is presented. So, we end up getting a different sentence. The sentencing court's explicit, on-the-record oral rejection of the first plea agreement, the "you just can't do it this way," speaks for itself. The substance of the original disposition further evidences that rejection. Most critically, the first sentence of the document's respective sections 2.b relating to count 30 are set forth below with emphasis added. So in the first plea agreement, count 30, sentencing withheld. This is the marbles coming together. Sentencing withheld until the completion of the initial trial of this case. First plea agreement. Original disposition. Count 30. Until the completion of the initial trial of this case. So we delete this. We delete sentencing withheld. The sentencing court deleted sentencing withheld to reflect the terms of the adopted plea agreement. The sentencing court's very specific deletion of a core term of the first plea agreement establishes that the sentencing court understood that the first plea agreement did not reflect the effective agreement between the state and Mr. Sledge. The sentencing court said what it meant and meant what it said when you said you just can't do it this way. The sentencing court rejected the first plea agreement both orally and in writing as reflected in section 2B. It never came into effect and has been void at all times relevant to this motion. Following the rejection, this is where it comes full circle on this issue. The sentencing court did not satisfy the requirements of Superior Court Rule 3310. You're supposed to give him the chance that he could withdraw. Upon rejecting the first plea agreement, the sentencing court was obligated by Superior Court Rule 3310 to personally inform Mr. Sledge of his right to withdraw his guilty plea. Such notice was not given. Instead, the sentencing court proceeded to accept the adopted plea agreement and entered the concomitant original disposition. Resultantly, Mr. Sledge's procedural rights under Superior Court 3310 were violated. This violation demands the reversal of Mr. Sledge's convictions. So there you go. That's another, I think this is another really strong argument. And I mean, again, a lot of these, I think, would take us right back to, we got to go back to the beginning a little bit. And this is just, can you imagine if we had convictions in the YSL trial? And I say that lightly because I'm speaking about, you know, the two that took it all the way to a jury verdict, right? But there's obviously, I would argue that some of the pleas, maybe that stuff was impacted by Sledge's plea deal, and maybe some of these same issues are present in other plea deals that were entered in this same December plea deal palooza. But you have an issue with this plea deal, the terms of which end up being void. You're not supposed to be able to use the plea deal against this individual. I'd imagine you also, if this was rejected and he had the opportunity to withdraw and he did withdraw, I would imagine that everything in his plea deal, you wouldn't have had that be used at trial. Like, think of the butterfly effect here, as far as this relates to other individuals named in the indictment. Oh, man. That's crazy. Argument 6. The trial court's revocation. So now we're in the revocation of probation. Of 5 years of Mr. Sledge's probation constitutes an illegal sentence because Mr. Sledge's underlying sentence did not contain any special conditions of probation. The state's petition to revoke Mr. Sledge's probation did not allege the violation of any specific special condition of probation, and the trial court did not find that Mr. Sledge violated any specific special condition of probation. And we got to hear about this in the June motion, and I think if you guys have ever, and Jim's channel is great, he covers a lot of different issues with great insight, and also a lot of humor. But one of his things, you guys remember, those ugly dispositions from Fulton County where they have the red text, the thou shalt not possess no guns, all of that stuff, the headers. We'll have headers for sections. We'll have a header for a section 2 with no header for 1. And then there's nothing under the header. It just jumps to another section after. All these different issues. This is the hot mess that Jim, and I'm assuming Tiffany, played a part in this argument, but I feel like this really drove Jim nuts. They have a section for special conditions, and then there's nothing listed under them in this disposition sheet. So this is that argument, that pet peeve, actually coming out into an issue where now we have a whole argument, legal argument being made, because the documentation was so sloppy, reckless, haphazard, careless, stupid. So probation revocation is governed by OCG 42-8-34.1. That's Legary v. State. We're going to call it 34.1. Provides that a court, after finding the violation of a general condition of probation, may revoke the balance of probation or not more than 2 years of confinement, whichever is less. Now this is, we've looked at this in the other motions, but this is, we've got to look at like 4 boxes here, right? You've got general for special conditions. And then for each one, you have a timetable. So if we find a general condition, the room we have to play with to revoke someone's sentence cannot exceed 2 years. And if the remaining balance is only 6 months, as an example, we have to go with the lesser value, which means the maximum that we can revoke, that the court can revoke after finding a violation of a general condition, would be limited to the lesser remaining value. So in my example, the 6-month balance of probation. At most, it could be the 2 years. If the remaining balance exceeds 2 years, oh well, too bad, too sad. Can't do it. Now, in contrast, a court finding that a probationer has violated a special condition of probation. So let's go to the other box. Special condition. you may require the defendant to serve the balance or portion of the balance of the original sentence in confinement. So, different timetable. And here, remember, we're finding, we're going to look at the violation. We got to go back to the timetable math. So let's see how Jim lays it out, and Tiffany. And sure, I keep saying Jim here because I know this is one of the things that really grinds Jim's gears, but I'm sure it grinds Tiffany's too. In short, courts cannot revoke more than 2 years of a probated sentence unless it finds that the probationer violated a special condition of probation or committed a new felony. The trial court, this is Singleton v. State, the trial court was not authorized to revoke the balance of Singleton's probation. In Clicka, that's a cool name, v. State, vacating 3-year revocation predicated upon violation of general condition. And Bergen v. State, revocation, oh my god, there's a lot of cases here. Bergen was revocation of more than 2 years of probationer's probation was prohibited. Harvey v. Meadows, the sentencing court erred by ruling that probationer had violated a special condition of probation, and it was authorized to revoke no more than 2 years of his probation. So in this case, the court made a mistake and thought it was a violation of special condition when it was only a general. And because of that, they ended up sentencing too much. They revoked too much. The legality of a given sentence is a matter of statutory interpretation, and the trial court's interpretation is subject to de novo review. So recognizing the significant consequences to a defendant for violating a special condition of probation, the General Assembly amended 34.1 and thus required, so they make this more explicit. There we go. Because there's significant consequences, they made this clear cut. And they're requiring, after this amendment, they're requiring trial courts to warn defendants of those consequences in a specific manner, in writing and place in the sentence, so as to ensure that a defendant would be notified of those consequences. So, there's no leaving it up to chance. Oh, we're going to decide this was a special condition that you violated, and we're going to revoke more. Nope. You've got to be informed of all of this. You have to know. It has to be explicitly delineated. It's got to be in writing, because it's a huge consequence. It could be the difference of maybe we can revoke a maximum of 1 month versus we can revoke 35 years. Should be informed. So this is why they thought it was such a serious issue that they amended 34.1 to make this clear. So let's see. Harvey v. Meadows, specifically 34.1a provides that the term special condition of probation or suspension of the sentence means a condition of a probated or suspended sentence which, 1, is expressly imposed as part of the sentence in addition to general conditions of probation and court-ordered fines and fees, and 2, is identified in writing in the sentences as a condition the violation of which authorizes the court to revoke the probation or suspension and require the defendant to serve up to the balance of the sentence in confinement. So, I mean, to me, that's pretty explicit. You have to delineate the special condition. It has to be expressly imposed. It has to be identified in writing. We have here, quote, the substantive or essential requirements of 34.1a are that the trial court warn of the consequences of violating a special condition, that the warning be in writing, and that the warning be in the court sentence. And. A court's oral warning does not satisfy either the substantive or essential requirements. 34.1 must be strictly construed. Of course, where no rules or regulations are prescribed in the probated sentence and no violation of a prescribed rule or regulation is alleged, the court is without the authority to order the defendant incarcerated upon the theory that he has violated the terms and conditions of a probation sentence. Courts strictly construe the requirements of imposing a special condition of probation. That's Gardner v. State, finding that conditions serving as a basis of revocation did not satisfy requirements, even though the Court of Appeals agreed that the condition was in all likelihood intended to be a special condition of probation. So this is not good enough. We can infer, we can use our common sense and say, oh, they just made a mistake. It's just a typo. They intended for this to be outlined as a special condition of the probation terms. But since they did it, obviously that's what they meant to do isn't enough. It's not enough. So, well, let me drink some before I lose my voice a little bit. I should come up with like an intermission song. I can sit here and drink some water, have a cough drop real quick without being all Glanville in the microphone, clinking a cough drop around on you guys. Also, huge thank you, KC Dog. Good to see you. I've been a member for 12 months. You guys have, that's a whole year. It's a whole year. Hope K&W fam is in great health and wish success. Yes, I love this message. I love you guys. So I always love how often when you guys use your membership messages, you get like the 1 a month message or you just drop something in the chat. You guys are always thinking about the whole chat, and that's super awesome. Gloria, good to see you, says, good morning, Kat. Thanks for the membership. So I think you're on 3 months. So have you gotten a lucky 3 gifts in a row? Is that what you mean? So I think you got a gifted membership from somebody if you're saying thank you. So shout out to the generous folks that gift the memberships here. I think Gloria has gotten 3. Thank you so much for being here, though, and hanging out, Gloria. And then Kay Schmidt said, hold on, we're dropping gifts. I just saw this pop up. Kay Schmidt always dropping gifts. There's a good chance that Gloria's gotten one of those gifts in the past. Dropping another 5 today. Thank you so much for always supporting Kay Schmidt. Thanks for hanging out with us. KP says the Glanville cough drop. When we were doing like the replays, there was one day where he was sneezing into the microphone. I think the tissue box was close. And it was like ASMR. You could hear him rip a tissue out of the box because it was so close to him. And it was so much louder than everything going on in the court that my ears were starting to hurt. Michelle, thank you for the super. Says, which ground did his probation get revoked? So this is actually the argument we're getting into now. You sent this message, it looks like 15 minutes ago, 16 minutes ago. So, but this is, back then we weren't at the issue yet. Now we're getting into the nitty gritty of this. Which ground did his probation get revoked? Well, we have problems there. Because Abate just said he violated special conditions. And then Whitaker said, I find that there were violations of the special condition as alleged by the state in their motion, in their petition. So the judge is explicitly stating that she is relying on what was alleged in the petition, but there is no specific allegation made of what condition was actually violated. And there's no gray area here, because it's important for us to know, well, was it actually a special condition or was it general? Because that impacts the timetable. And you have to inform, it's such a serious issue that we took case law and we amended 34.1. We amended the statute and said, look, we're going to make this expressly stated that you've got to put this in writing. You've got to be explicit, because it carries such serious consequences if it isn't specified that it's not right to not do these things and inform the defendant. If you do this specific thing, you could be facing a revocation of the entire remaining balance. And not for nothing, but we saw that we end up having a sentence extended here. There's all sorts of issues here. But Michelle, we are getting into this right now. I think this is really problematic for the state. And again, it all goes back to, they didn't ask about if he wanted to withdraw his plea. But if someone doesn't understand when they're signing off on something and agreeing to probation, that if there is a revocation, if they do this one thing, the max they could be facing is 2 years versus the max they could be facing is maybe the whatever remaining balance of the 30 years. There's no reasonable person, no rational person in this world that will tell you that doesn't make an impact on somebody's decision making. At most, I'm at risk of 2 years versus at most, I'm at risk of 30 years is a huge difference. So, and the law, the case law, and the statute here really looks to be in Sledge's favor here. And it looks like the state and 2 trial judges didn't give an F on how important this is for the individual that's on the defendant's side of the aisle. But Michelle also says, is the state saying he lied on factual statements on the plea deal, or he lied on the stand? If he was telling the truth on the stand, then he followed the rules of the plea deal. Well, and that's the thing. I mean, we all know that the issue was they didn't like the way he testified. That's the common sense issue. But the ruling from Whitaker is that she found a violation of a special condition of probation as alleged by the state in their petition. I don't really see how that was notated as a special condition of probation. I don't see that being alleged in, and they're going to get into the specifics here. But I didn't see that specifically outlined as a special condition, a violation of a special condition in the petition. So lots of problems here. Big issue all around. And Michelle, I think you're getting to the heart of it, is they're just not happy with what he said, and they just rolled the ball down the hill to revoke his probation. And along the way, they ignored a whole bunch of things that they're supposed to be doing and things that they're supposed to look for, both the state and the trial court. And then his counsel at the time, Attorney Derek Wright, was sitting down, argued something about item line number 8, factual acknowledgement number 8, and then was just like, oh, okay, whatever. Like, very ineffective. And none of them have to deal with the consequences. They all get what they want, except for MOUNK TOUNK. MOUNK TOUNK's the only one that deals with consequences of that. So nobody cared. So I'm with you. Thank you for the super. We're going to get into the specifics of the issues. But really, it just seems like, screw it. Just get it done, and the court's going to agree with whatever we say, and they're not going to look at the fine print, even though case law and statute requires it. Terry Friday says Justice Serve TV is like 10 subs away. Yes, let's get them. Yeah, I'm still seeing 25.9K. And they're doing Donna Adelson stuff this week, you guys. So also another, especially if you're not watching during the day but want quick recaps, they're a great place at the beginning of their streams. They recap the day before. So you could tune into like the first 15 minutes of their daily streams to see what happened the day before. Super awesome. But I'm seeing they're really, really close to 26. So, and even if they hit it, go follow them anyway, because they have a ton of great stuff. They also, we've been talking a lot about Relly, Joe Tacopina, ASAP Rocky, because the civil stuff is still ongoing. There's supposed to be a hearing on the 8th. They've had Joe Tacopina on for interviews, so I expect that they'll give some updates on, what happens at any of these hearings. But I also would guess that perhaps they'll end up having Joe Tacopina on to come speak to the people. So they do a lot of great interviews, have a lot of great guests on. But that's something I'm expecting that they'll cover coming up. So if you're interested in that, that's another reason to follow them. And then, love always Jamie. So we actually see ineffective assistance of counsel raised for the first time in this appellate brief that we're reading today. So they didn't raise the issue in the motions that they filed with the trial court, but they're doing it here. So let's see. Let's get into this. We've got Mr. Sledge's sentence did not include any special conditions of probation. Now, this is a bold header. Because, look, Michelle's question was, what exactly was the thing they were even arguing? And we want to know. We want to see the court answer for that. What were you agreeing with? What did the court actually agree with them was the specific violation? Or was it just a general, okay, I'm going to side with you guys because I agree he was doing something akin to perjury on the stand. Right? That was one of my biggest pet peeves of the trial, was Paige saying, I found what he did kind of to be akin to perjury. That's not how a probation revocation works. If someone commits perjury, then the state has the discretion to choose to go down the pathway of going forth with some type of charges relating to perjury. When it comes to a revocation of a sentence, revocation of probation, because somebody violated terms and conditions of the probation, procedurally, you have to stay inside that box. You have to say what was actually the violation. And just going, well, I just thought it was akin to perjury, is not it. So, still mad at Whitaker for that one. but I love this header because it says Mr. Sledge's sentence did not include any special conditions of probation. And if they can support this argument, let's go back to the boxes. We already know that Page revoked 5 years. You can only do that if there was a violation of a special condition of probation. And we know that those special conditions, we just looked at the case law already, have to be expressly defined in writing. The defendant has to know what they are because the consequences are so great, they must be informed of the risks and the consequences. Well, if you don't have any special conditions of probation in the sentence, at best you can only be over in the general conditions box, which puts you at a 2-year cap, maximum. So this header alone, if this is supported, if they can support, this is a strong argument right here that the 5-year revocation is a nope. Because it would put you at best in the maximum 2-year timetable. Oh, man. Here, a plain reading of the original disposition, which was in effect at the time of the revocation hearing, quickly reveals that no special conditions of probation were imposed. At the bottom of page 2 of the original disposition is a section titled Special Conditions of Probation. Notably, the section specifically and repeatedly uses the defined term special conditions of probation. Consistent with the requirements applicable to the imposition of special conditions of probation, the section reads as follows. So this is the general language that's included, right? They included in this disposition. The defendant is advised that violation of any special condition of probation may subject the defendant to a revocation of probation, and the court may require the defendant to serve up to the balance of the sentence in confinement. The defendant shall comply with all special conditions of probation as follows. While this constitutes an adequate written warning for purposes of establishing a special condition of probation, there are no special conditions of probation following the as follows. Oh, this is just, man. I know Love wrote that out, helped write that out. To the contrary, there is another section entirely titled 2, Negotiated Sentence. Now, let's, in the chat, we know Jim has this thing, and it's like, I think it's imparting on a lot of us, where we notice a lot more typos and misspellings, people getting names wrong. It's like an inside joke. It's not really inside, but it's like something that I think is fun in games. I see a lot of you guys over on X, like, tagging each other when you see a major typo in a filing, even in cases unrelated to Fulton County. Right? It's just something that, like, we're all bonding together as a community about. It's one of Jim's huge pet peeves. This started as a, wait, what? How do you have a section and then the section's blank and then it jumps to another section? It started as a, what is this? This is a hot mess formatting. Is it a typo? This is sloppy. But now we're seeing how this is developed out to a major, it's insufficient. It's an insufficient way to inform somebody. Sure, you give them the warning that if you do these things, we could revoke more than 2 years. Because it would move you into this timetable over here. But then you don't tell them what those things are, but then we have a whole revocation petition and hearing. Yeah, you violated those things that are blank. And there's so many layers to get from, like, the law to the argument to pointing out why it's an issue. And this is it. This is all of it coming together. This sloppiness is more than just a funny hoo-ha thing. It's something that's depriving somebody of their rights to know what consequences they face if they don't abide by certain terms set forth. Because nothing was set forth. Oh. So let's get into this another section entirely, this negotiated sentence thing, which is not special conditions. This is where we have B, count 30, until the completion, we're missing the words here. The sentencing withheld, this is where it's missing. Until the completion of the initial trial of this case. After the initial trial of this case, provided you have complied with the special conditions outlined in B, C, D, F, and I of Section 3, special conditions of sentence of this plea agreement, the state agrees that the defendant should be allowed, and there's 5, footnote, it bears mentioning that due to the use of passive voice, the entity responsible for allowing Mr. Sledge to withdraw his guilty plea is not identified, reducing it to illusory consideration. So this footnote is recalling a previous argument and issue where the court was supposed to give Sledge the opportunity to withdraw his plea after it was rejected by the court. And now they're calling out the passive voice here. That is spicy, but that's also a good point. Oh, why did it make me jump? Let's see. Where was I? What's a good word I could use? I guess we could just find footnote 5. We were on like page 40 something. Okay, here we are. I don't know why that jumped us. But going back up here, I love a good footnote. Let's see. Okay, so to withdraw, well, let's read this whole sentence. So count 30 until the completion of the initial trial of this case. After the initial trial of this case, provided you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3. So what's going to be after this section 2? Special conditions of sentence of the plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Among other things, the negotiated sentence section establishes that section 3, special conditions of sentence, contains, as one might expect, special conditions of sentence. The items contained in section 3 do not even purport to be special conditions of probation, which, at the risk of stating the obvious, should be addressed in the section titled Special Conditions of Probation. I feel like fire was spewing out of the pen when writing this. Satisfying. This is at the Court of Appeals, Jamie. This is at the Court of Appeals. This is Tiffany Adams, the Fit Lawyer ATL, and Jim Robichaud, or Jim R, or HappilyAngryLawyer. So the two of them are filing this with the Court of Appeals. And some of these issues have been touched on with motions filed at the trial court level. But the first trial court motion resulted in Whitaker deciding to take the 5-year, vacate the sentence on count 30, and just take those 5 years and plop them onto count 1, which is now the basis of new issues raised in the June motion to the trial court, which Whitaker said, hey, go to the appeals court first. And that's why we're here. But that issue is also being carried over and raised in, I think there's 9 arguments total. So all of that is here. Let's see. Where are we? Okay, so satisfying the enumerated special conditions of sentence would entitle Mr. Sledge to withdraw his guilty plea. Failing to satisfy the special conditions of sentence would result in the loss of that entitlement, but apparently nothing more. There is no indication within the 4 corners of the original disposition that the violation of a special condition of sentence would constitute a violation of the terms of probation, let alone a violation of a special condition of probation. So this argument here actually extends to, it wouldn't even be a general violation. We wouldn't even just dump down giving the benefit of the doubt into the general condition bucket. Finally, should any doubt remain, The items contained in Section 3, the special conditions of sentence, do not satisfy 42-834-1A2, which conditions the validity of special conditions of probation on the corresponding written sentence, providing a written warning, indicating that the violation of such special conditions of probation could result in a revocation of the balance of the probated sentence. Here, the applicable written warning, contained in the special conditions of probation section, is limited to special conditions of probation. There is no corresponding written warning for violations of special conditions of sentence. Here, as was the case in Gardner, so here's a supporting case, the sentencing court, in all likelihood, intended to impose the special conditions of sentence as special conditions of probation. But, like in Gardner, the sentencing court failed to follow the two requirements in order for special conditions of probation to exist. Accordingly, this court was without authority to revoke 5 years of Mr. Sledge's probation sentence. We have a footnote. The original disposition also did not incorporate or otherwise include any defendant's factual acknowledgments. So we're just going to throw that in there. And I guess that is important because if you're going to say orally, if you're going to try to make an argument that, oh, I know we didn't put it in writing as we're required to by case law and 34.1, but we said something in court. Well, you are leaning into this akin to perjury thing. But if you didn't include the factual acknowledgments in the original disposition, you're not really including any sort of, we can't even infer that they meant to say you have to say all these things in court because you didn't include the things that he's supposed to say are true and that he's acknowledged into this disposition. So going back to this hot mess question, your question isn't a hot mess. Your question reflects how obvious of a hot mess what happened with this probation revocation hearing is. Michelle, this is it right here. Factual acknowledgments aren't there. Oh my goodness. And also, thank you, Michelle, for the 5. Says the problems with using people who want out of jail and finesse the truth as witnesses, it's a hot mess. Yes, and don't forget that layer of too dangerous to let out, but a week later, you know what, we'll let you out. We won't even include a term that you have to stay away from people that you've antagonized and have harmed with all of your crimes that you were too dangerous to get a bond for. But now we'll just let you go. We'll let you get out. A great package there of logic from the state. Yes, Fit Lawyer, Tiffany Adams. Without Tiffany Adams, Jim wouldn't be able to do this because he's not licensed in Georgia. So he had to find an attorney that not only was willing to take the work, but also willing to work with Jim. And I think Jim is a person with, got to be one of my favorite attorneys out there. But, Tiffany had to give him the benefit of the doubt. They didn't know each other before. He probably came in as like, well, I worked in the civil space, but I want to take on this criminal issue. And, they met and they saw eye to eye on this. Tiffany was willing to do the work. Jim was willing to do the work, and they were on the same page and willing to give each other a chance, which is just the two of them. This wouldn't be happening without either of them. So, and I think it's a huge testament. Jim wanted to work with the Fit Lawyer, and the Fit Lawyer, once meeting Jim, was like, oh my gosh, let's do this. So, a super awesome, side story that made all of this happen. So, and yes, HTX is over on Twitch using the fry emoji. Good to see you over there in the purple world. It is on like Donkey Kong. That's another thing. Maybe I'll do some gaming streams on Twitch. I was very proud. A long time ago, I achieved, this is Donkey Kong 1. So the original Donkey Kong Country series, not like the old school, NES Donkey Kong, but the first Donkey Kong Country series. I wanted to make it through without, getting when you die in Donkey Kong, you can, lose Donkey or Diddy. If you don't know, Diddy is the little chimps name. It's not like P. Diddy. So Diddy's name is like ruined forever in the Donkey Kong series. But like you have two of them and like you lose one if they get hit, and then if you lose the other, if you lose both, that counts as a death when you lose both. I wanted to complete the game without a death where you lose both. And I did it for so many practice runs, and I finally made it through without a death. I was so proud of myself. Maybe I'll do that as a run. Yeah, Diddy Kong, no Diddy. Oh, man. Luckily, that's not like a common name, right? Like, not many other people. But Diddy Kong's name is definitely... Like, listening to video essays and stuff now where people talk about Donkey Kong. Donkey Kong gets discussed a lot because if you guys are into music, even if you're not into video games, some of the coolest music lore and video essay content on YouTube is how gaming music is made. And one of the... And I can't even explain it the way a video essay would, but when you're dealing with like a game cartridge and you only have like little logic of pieces and instruments that you can fit on this cartridge, because you can't just download MP3s onto the cartridge. I think for Donkey Kong, they produced the whole soundtrack, beautiful soundtrack, with like 8 instrumentations and just told it what to do at a given point in time. So it'd follow like, at this moment, we're playing this beat all the way through rather than it just playing a recorded track. I can't explain it, but it's really cool. I totally recommend, if you guys like music, just go search the Donkey Kong soundtrack content. Yeah, that guy Nick, I'm so serious. I spent so long trying to do it. Because there's certain stages in Donkey Kong where there's like bees, and you gotta time your jumps over the bees. And no, you have to do it like muscle memory. It's really not a skill thing. It's a repetition and muscle memory that made it possible to do that. It's really not a skill thing. It's a time devotion to repetition. I dedicated the time. I do not have a special skill set. Let's see though. Let me get back over here. The state's revocation petition did not allege the violation of a... Okay. Okay. Oh, wait, we didn't do this then. It just seems familiar, but this is new. So the state's revocation petition insinuates, but never actually alleges. So now we're talking about Adam Abate's petition to revoke, like October, whenever he submitted that, of 2024. That Mr. Sledge violated a special condition of probation set forth in the original disposition. Section 3 of the revocation petition, titled Defendant Violated Special Conditions of His Probation, sets forth the state's argument. All mentions of special conditions contained in Section 3 are briefly addressed below, with emphasis added. So the first sentence of Section 3 reads that the defendant has violated all the special conditions of his sentence outlined below. The conditions outlined above, as a footnote, the language of the conditions outlined above is excerpted from the first negotiated plea agreement. So they're not, oh my God, but attributed to the sentencing court's original disposition. Do you think Adam Abate doesn't know the difference between looking at a first negotiated plea agreement and an original disposition? So somehow in this petition, we're acting like the language that we need, these special conditions of sentence, we're picking from a different document and attributing it to another one. As established in the preceding section, special conditions of sentence are distinct from special conditions of probation. Next, the revocation petition asserts that the defendant directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments. Again, special conditions of Mr. Sledge's plea agreement are not special conditions of probation. More fundamentally, the void first negotiated plea agreement was not Mr. Sledge's written sentence. And void is in parentheses here. So this is the call out of, You're using a negotiated plea agreement. You're taking language from a negotiated plea agreement and attributing it to being the sentence, the disposition. And moreover, you're taking it from the negotiated plea agreement that was voided out. The revocation petition's references to the rejected first negotiated plea agreement are unavailing. Oh, man. Adam Abate. The revocation petition continued. Most importantly, the defendant acknowledged that he understood that any violation of the special conditions of this plea agreement could lead to the revocation of his probation, with the district attorney recommending the maximum sentence. Footnote says, as discussed above. And in the trial court's vacatur order, the maximum sentence actually exceeded the statutory maximum sentence by at least a decade. Thus, the state threatened Mr. Sledge with an illegal sentence, and nearly 2 years later, turned around and used Mr. Sledge's acknowledgement of that threatened illegal sentence in support of its contention that Mr. Sledge is amoral. Oh, I bet this felt so good to write. I felt this. This is an FU. This is the audacity. This is an FU footnote. I just love them. I love, where is it? Yes, Keisha, Jim and Fit, Tiffany. I always love that Fit is like Tiff backwards. So Tiff, Fit, like in my head, Fit could be her name. Their passion for justice in my eyes will forever be an amazing moment in history. 1,000,000%. And I'm hoping to see, I know Joseph Papp with AJC is keeping an eye on this. So I'm looking forward to seeing AJC do some coverage. The great thing about AJC is when they do articles, sometimes with local channels, an article will just give you, here's what happened today and here's what we know so far. And it'll be like 2 paragraphs. But with AJC, they wrap in a lot of context every time they do a write-up. So I would imagine if they discuss this appeal issue, they would do a very good job of bringing in, the significance of MOUNK TOUNK's plea deal, the timeline of it, how it came into play at trial, and how, maybe the rest of the YSL code defendants that were awaiting trial 2 ended up also taking pleas. Trial 2 never happened. They do just great work. So I'm excited to see. I really do think that Jim and Tiffany's work deserves a bigger platform and realm of awareness. And of course, if they get a bigger platform, of course, it's going to mean more work for Tiffany. I would hope more work for Jim as well, although he has the barrier of he would need the pro hoc vice status to do Georgia work. But still, people being aware of the work that he's doing with stuff like this, a great reason for someone to say, yeah, let's go in on a case. I'll be your local attorney. Let's get you your pro hoc vice status. Oh yeah, this is a footnote. This is a footnote. KP is over. Kissin' Pink is now purple over on Twitch with the MOUNK TOUNK emojis. Yeah, and the MOUNK TOUNK emojis are one of my 3 free to use emojis because we can allow special emojis, 3, for followers to use even if they don't have a paid membership. So that's really a cool feature of Twitch. Yep, I'm going to pull these up. Michelle says Jim seems like he has integrity and a good sense of right and wrong. And gets super mad about it. I love and admire people that have a sense of stoicism, but I love somebody that gets in a rage. Like, 2 different things, both equally could be passionate about the outcomes, right? But there's just something that I love seeing someone fired up. It's like a sports fan cheering for their favorite team, getting the ball into the end zone or into the goal. Like, that's how I feel about someone being fired up about stuff like this. And then Factual Lie, I wanted to get to this. Factual Lie says, speaking of inadequate, Fani Willis ordered to redo record search in Trump case after judge rules her efforts inadequate. She catching L's after L after L after L. And I kind of always saw that case was going to be a long, drawn-out back and forth, right? Especially had multiple co-defendants that were fighting for it. But I always think the extra L to Fani Willis is She seems like the type of person that cares about her PR and her track record and her success. And she chose to pursue this case where now you're being told you didn't want to do these record search. You fought it. You were ordered to do them. And now you do the bare minimum and you're getting called out again because you're still refusing to do it right. Now you're getting all this extra press on you, this coverage where you just seem, I don't know, kind of like you're going, nuh-uh, I'm not going to do it anyway. But, you know, that's what happens when you like being in the media. People will start following your story, even the bad news. Chloe! Good to see you, Chloe. Oh my god, I feel like it's been a few weeks. But good to see you. Hope you're doing well. Chloe says, what fresh hell is this? So this is the appeal. We finally have an appeal brief filed for MOUNK TOUNK. So really good stuff. We're about 50 pages in. I think we're on like argument 8. We're through most of the deep dives into the arguments. But there's a lot of good stuff in here. And Jim and Tiffany have gotten to have some, you know, I think they're writing this with great posture, but they've gotten some spice and some, you're really doing MOUNK TOUNK dirty in here. And that's what's on the screen right now, is this nice spicy footnote. Which was from this sentence here, that the revocation petition continued, that most importantly, the defendant acknowledged that he understood that any violation of the special conditions of this plea agreement could lead to the revocation of his probation, with the district attorney recommending the maximum sentence, so they're threatening him with this illegal sentence, allowed by the law in the Georgia Department of Corrections. Again, the state does not identify any special condition of probation and does not reference the original disposition. They only reference language from the rejected plea agreement. The penultimate sentence, and the last to mention special conditions, reads, "It is evident that the defendant knowingly and willfully violated the special conditions of his negotiated plea agreement." So Abate is now naming the document that he, without naming earlier, was attributing to the terms of sentence, as if he was reading it, getting the language from the original disposition. But now we're finally getting this written in here that it's, no, you know, he's violating the special conditions of his negotiated plea agreement. Consistent with the foregoing, no special condition of probation is identified, and the original disposition is ignored. So, well, they're going to sum it up here. So we'll just read their summary. The revocation petition alleged that Mr. Sledge violated 1. Special conditions of his sentence, 2. Special conditions of his plea agreement, and 3. Special conditions of this plea agreement, and 4. Special conditions of his negotiated plea agreement. What's missing? What's missing, chat, in these 4? We read like 3 pages worth of how it is a requirement because the defendant needs to be informed, because not knowing what they're risking, facing these huge consequences if they violate, they must be explicitly informed of the specific special conditions, that if they violate these specific special conditions of their probation, they could be facing a revocation of the entire remaining balance. But not once. Not once is a thing that's required to be explicitly outlined. Alleged. Why don't they make the specific allegation? Could it be because there was never an explicit statement of what the special conditions of probation were? Because to me it seems like Adam Abate realized when writing his petition that section was blank. He's supposed to look at the disposition. That section is blank. We have the header section with a warning about if you violate these special conditions as follows, and then there's nothing as follows. It just goes to another section. It seems like Abate knows. Hold on one second. Sorry, I didn't want to pull a Glanville and like cough out loud into the microphone. But yeah, so isn't it interesting? Abate dances to like 4 different things, but none of them are the thing that are supposed to be what's referenced, unless we don't have a violation of a special condition of probation alleged at all. And it's required. And we know that Whitaker, well, this is the next section, so we'll just read it. The court's revocation order did not find any violations of a special condition of probation. So this is now moving on to Whitaker, following her decision based on the petition and the hearing. The court's October 18th order, 2024 order of revocation provided the court's findings. The preponderance of evidence presented compels this court to find that the defendant has violated the special conditions of probation as alleged in the petition for revocation. So the court isn't finding a specific violation, and they're saying they're just going along with what was in the petition, which isn't sufficient. No violations of any specific special conditions of probation were found. Conditions is... Uh-oh, we got a gym typo. Do I still have my red marker? Uh-oh. Pursuant to 34.1 C and E, Mr. Sledge's 5-year revocation is contrary to applicable law. A sentence is void if the court imposes punishment that the law does not allow. Such is the case here. Mr. Sledge's 5-year revocation is contrary to law, void, and must be vacated. 7. The trial court erred by taking judicial notice of appellant's trial testimony during the probation revocation hearing. And now this is a completely new issue. This was written out with a different format than what we read in, I think, the June motion to the trial court. But it was written a little bit differently. But here, this is something that's a new argument, right? So let's see. The trial court erred by taking judicial notice of the evidence it used to revoke Mr. Sledge's probation. Additionally, the trial court improperly acted as judge of fact and law and witness during the revocation hearing held on October 18th, 2024, by participating in a manner in which it had personal knowledge of disputed evidentiary facts. Is this the akin to perjury? Are we going to get an akin to perjury argument? Because that pissed me off. Contrary to the law, a trial court's evidentiary rulings are reviewed under an abuse of discretion standard. They're citing Norman v. State here. Georgia rules of evidence apply to revocation hearings. Whew. The trial court improperly took judicial notice of the evidence it used to revoke Mr. Sledge's probation. If a trial court intends to take judicial notice of any fact, it must first announce its intention to do so on the record and afford the parties an opportunity to be heard regarding whether judicial notice should be taken. That's from Mann v. State. The reasoning behind this holding is that unless an accused is informed at trial of the facts of which the court is taking judicial notice, not only does he not know upon what evidence he is being convicted, but in addition, he is deprived of any opportunity to challenge the deductions drawn from such notice or to dispute the notoriety or truth of the facts allegedly relied upon. And that's from Graves v. State. Moreover, there is no way by which an appellate court may review the facts and law of a case and intelligently decide whether the findings of the lower court are supported by evidence where that evidence is unknown. So the state filed a motion and petition to revoke probation, requesting an evidentiary hearing to determine whether or not Mr. Sledge violated the special conditions of his negotiated plea agreement with the intent to disrupt the trial of this case. Yet, during the hearing, no evidence was presented. Instead, the trial court improperly took judicial notice of testimony it witnessed during the trial and used that as evidence to revoke Mr. Sledge's probation. After the state opened, this is going again back to Michelle's question of, what is the actual issue? What was the state actually saying that he lied about specifically? And then now the court, without getting clarity on that, just made a finding anyway. So, let's see. After the state opened at the revocation hearing, it presented the trial court with state's exhibits 1 and 2, and a USB drive of Mr. Sledge's testimony on day 124, 25, 26, and 27, 127 of the trial as exhibit 3. In response, the trial court stated that everyone is aware, Your Honor, I witnessed it. I can take judicial notice of everything that I've heard during testimony, in which Mr. Sledge did testify. Now, no room to object here, right? She didn't ask any objection if I take judicial notice. After announcement that the trial court was taking judicial notice of the trial testimony, there was no opportunity to be heard from either side regarding whether judicial notice should be taken. This was improper. The trial court then stated that it did not understand what Exhibit 3 was and asked the state to explain. The state stated that it was the YouTube streams of the trial from the days that Sledge testified. The trial court again stated, I will just take judicial notice of it. I mean, if you want to make it an exhibit, then that's fine. I'm not going to be relying on that since, it's only the official transcript that is the official transcript anyway. But I was here and witnessed it, so I will take judicial notice of it. Again, there was no discussion following this announcement regarding whether judicial notice should be taken, which was improper. In this case, the trial court improperly took judicial notice at the revocation hearing, resulting in the exact scenario the Supreme Court sought to avoid in Graves. Without any evidence presented at the hearing, appellant was deprived of any opportunity to challenge the deductions drawn from such notice or to dispute the notoriety or truth of the facts allegedly relied upon. In addition, since the evidence is unknown, the Court of Appeals cannot review the findings of the lower court and whether they are supported by evidence. Since the evidence relied upon by the trial court to revoke Sledge's probation was improperly taken under judicial notice, the state failed to prove a violation by a preponderance of the evidence. Mr. Sledge's revocation should be overturned. Yeah, so how do you prove a standard? Like, the state has to prove it. You can't just have the judge tag in and substitute and say, I gotcha. I find this akin to perjury. The trial court improperly acted as judge of fact. This is B. The trial court improperly acted as judge of fact and law and witness at the probation revocation hearing in violation of OCGA 24-6-605. The trial court improperly acted as judge of fact and law and witness during the revocation hearing held on October 18th, 2024, in violation of OCGA 24-6-605. The law prohibits a judge from testifying as a witness in a matter before him. A&M Hospitalities v. Alimkandani? Similarly, the Code of Judicial Conduct prohibits a judge from participating in a matter in which he has personal knowledge of disputed evidentiary facts, or if he has been a witness in the proceedings. The facts at dispute during Sledge's revocation hearing were whether or not his trial testimony violated the special conditions of his plea agreement. The facts were disputed, yet several times during the revocation hearing, the trial court stated that it witnessed an action the state was accusing Sledge of committing in violation of his plea agreement, and due to witnessing said action, the trial court did not take any other evidence of those actions. See, this is something that I think as a gut feeling, a lot of us were like, is this really the way that this goes? So it's really cool. I think it's interesting to see it laid out in words, in a legal argument. That because Whitaker did what we saw her do when we were watching this hearing live, we're seeing it written out and spelled out what the issue was. There's a fact at issue, facts in dispute, but she just goes, yep, I already know that's not even an issue. It's not disputed. I already have a decision. Nobody can raise any. I'm not going to give you guys an opportunity to object to me taking judicial notice. And hearing it spelled out just kind of just takes something that sits here like a gut feeling and gives us words. For example, the trial court said, everyone is aware, Your Honor, I witnessed it. Wait, the trial court said, everyone is aware, Your Honor? I witnessed it? Did Paige say Your Honor to herself? The trial court said, everyone is aware, Your Honor, I witnessed it. I can take judicial notice of everything that I've heard during testimony in which Mr. Sledge did testify. In another instance, the trial court said, but I was here and witnessed it, so I will take judicial notice of it. At no point during the revocation hearing was any testimony of Sledge from the trial placed on the record. An unofficial YouTube recording was provided to the court by the state, but the trial court stated it would not rely on it since it was not the official transcript, which was not prepared at the time. Oh, you know what? This is clicking too. So they had the opportunity to take a look at evidence, and then Whitaker was just like, no. That's declining the opportunity to have the state argue evidence to prove to the preponderance. Whitaker's like, nope, you don't got to do that. That's waiving them of their burden. By taking judicial notice of the actions the trial court witnessed itself, the trial court participated in a manner in which it had personal knowledge of disputed evidentiary facts. This action was an abuse of discretion by the trial court, as it acted as a witness and judge at the probation revocation hearing. Due to this violation of law, Mr. Sledge's revocation should be overturned. I'm interested in seeing if the appeals court even wants to weigh in on this. I'm like, well, I feel like this should succeed, but, I feel like, I don't know if the appeals court's gonna want to do it, so we'll see. 8. Appellant received ineffective assistance of counsel during plea negotiations and sentencing. Isn't it amazing that we have so many other arguments that, like, everyone was like, ineffective assistance of counsel, his attorney isn't doing anything. But yet the state messed up so badly that even if we didn't have ineffective assistance of counsel, I feel like there's a lot here that I hope whatever panel of judges is sitting on the Court of Appeals here that's going to review this, I hope that they just, like, look at it, read it for what it is. If they actually read through it and give it the time of day and aren't on some funny business, I don't see how at least some of these arguments don't win. And says they will dodge that issue so fast. Yeah, that's what I expect. So guys, that was argument 7. So when we get a response, and obviously in between, the state's going to have a chance to respond, and then Jim and Tiffany will have a chance to reply to their opposition. So we'll look at all of those things in between. But when we get to the decision hour, we definitely want to look and see about 7 here. See what they say about argument 7. Also, a big thank you here. I saw, was it M? Where's M Shannon? Yay! Okay, so there it is. So M Shannon got her mug, her buffering mug, and loves it. Yay! And actually it arrived the other day, just got home though. Oh my god, I always love when there's a package waiting for me. Typically I have the issue of, working from home. If I'm not, like, running to the grocery store, sometimes a package will be sitting at my door for, like, a day or two. If it's not the type of delivery that notifies you that it arrived, I'll just walk outside. Oh, it's been sitting there for a few days. So luckily I haven't had any problems with missing packages. But that's super awesome. And Nick got one too. Nick got his mug. That's awesome. I should put a cheers mug. Justice Serve TV has their mug as an emoji. And it's a good way to cheers in the chat. I should do one of those. Take a play out of their book. Let's see. Yes, Trakeisha, I agree. The state's response will be interesting. It's gonna be a lot of screaming and bold text. I mean, I don't really have a time frame, but I think they end up getting, like, a good amount of time to respond to each other. So let's just guess, like, a 2-month timetable. And see. I don't know the exact time limitations, but they do get time to respond, and then Tiffany and Jim will have time to respond to that. So that needs time to play out. Things move slowly. The state's response is going to be, but Glanville said, Taco Tuesday, good to see ya. out April O'Neil's baby daddy. I think you're saying you got your mug also. Yay! Oh my god, yeah, we definitely got to get the cheers going in the chat. I'll get an emoji going. So let's see. Appellant received ineffective assistance of counsel during plea negotiations and sentencing. I feel like this is what everybody wanted to hear the arguments on, and I like just gave you guys a bunch of suspense and side story there. The existence of a federal constitutional right to effective assistance of counsel, absent an implicit right, is now long and well established in Supreme Court decisional law. Mr. Sledge received ineffective assistance due to counsel's deficient performance during plea negotiations and the plea hearing. For those reasons, his probation revocation should be overturned, and he should have the right to withdraw his guilty plea in order to correct a manifest injustice. Claims of ineffective assistance of counsel are evaluated under the Strickland standard. The trial court's factual findings are subject to clear error review, while its legal conclusions are subject to de novo review. That's Sambo v. State. Appellant received ineffective assistance of counsel when counsel allowed him to enter a plea to a charge he was not charged with in the indictment. And for what it's worth, this seems really obvious, right? We've heard about it so much. But what's a really scary thought is state either did or didn't notice it, and if they noticed it, they weaponize the expected naivety of the defendant, and maybe that the judge and defense counsel wouldn't notice. Trial court did or didn't notice it, or notice an issue and tried to make it work anyway. I mean, there's no doubt in my mind that the same issue with 133 and 131 is happening in other instances. So, Fulton's gonna Fulton. Mr. Sledge entered a plea with the assistance of counsel on December 28th, 2022. To prevail on his claim of ineffective assistance of counsel in the context of a plea bargain, Mr. Sledge is required to show that his counsel's representation fell below an objective standard of reasonableness and that the outcome of the plea process would have been different with competent advice. Let's see. Mr. Sledge was charged in indictment 72. This is the second one, with 2 counts. Count 1 was conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, and count 2 was possession of a firearm by convicted felon, 131. Despite the body of count 30 referencing 133, the substantive language of count 30 charged Mr. Sledge with the elements of 131. Mr. Sledge's trial counsel failed to make note of this and negotiated and entered a plea deal for Sledge on counts 1 and 30, as if he was charged with 133, which allowed for a sentence of 15 years, such sentence to run consecutively to any other sentence Sledge received. Contrary, the charge Mr. Sledge was actually charged with only carried a sentence of 5 years, and such sentence could run concurrently with count 1. The failure of Mr. Sledge's trial counsel to recognize his actual charges led to Mr. Sledge being sentenced to a longer sentence and a void sentence. Failing to understand the nature of your client's charges is deficient performance which falls below the standard of reasonableness. So, and remember, this is the bar, and I hear people say all the time, like, the standard of reasonableness is very low. So here we're arguing that this not even understanding the charges puts you below that bar. And I'm here, I'm a lay person. I would say an attorney should understand what their client's being charged with. That's like the first thing you gotta do. This means Mr. Sledge never had an understanding of the charges against him. Ooh, they're layering this. This is going to be beautiful. This means Mr. Sledge never had an understanding of the charges against him, as his own counsel did not either. So what does this mean? This is beautiful. If Sledge can't understand the charges against him, how can he knowingly and voluntarily accept the terms of a negotiated plea agreement? Sentences imposed pursuant to OCGA 133 must be for a term of 15 years and must be run consecutively to all other sentences. Mr. Sledge was led to believe that count 30 charged 133. Thus, he sensibly and successfully negotiated for concessions with respect to count 30 as 133. Yeah, get him, Jim and Tiffany. We're going to call him Jiff. Jiffany. The old Tiffany. He secured a promise that count 30 could be null-prossed, that the sentence could be suspended, and that the sentence could be served on probation. From Mr. Sledge's perspective, those are the most critical points of the plea negotiations. The count 30, we're going to get again, we get another opportunity, you guys. That count 30, in fact, charges 131 renders the concessions that he negotiated.
Your point is pointless.
Section 131 carries a maximum sentence of either 5 years or 10 years, depending on whether the defendant has previously been convicted of violating 131, and can be run concurrent with other sentences. Thus, had Mr. Sledge known the true charges and the corresponding sentences, he would have approached negotiations entirely differently. Again, as discussed in Section 1B, so way earlier in the stream, as in Clue, where the ineffective assistance rendered Clue's guilty plea involuntary, the ineffective assistance provided to Mr. Sledge undermined the voluntariness of his guilty pleas to both counts 1 and 30. So this ineffective assistance of counsel is we shouldn't even have gotten here, and even though we got here, it also impacts this package plea deal. Because you can't unmarry the concessions that Sledge understood that he was negotiating for, based on what he understood about the charges. You cannot unmarry counts 1 and 30. That negotiations, it was a package deal. And ineffective advisement on the issue with count 30, whether it was 131 and 133, undeniably impacts the approach to count 1. So Mr. Sledge entered a plea to a charge he was not charged with in the indictment, which led to a void sentence. Had Mr. Sledge had competent advice, he would not have negotiated himself into a void sentence. Mr. Sledge also would have approached negotiations differently had he known he was not facing mandatory consecutive sentencing. With competent advice, Sledge's plea negotiations would have gone differently. I agree. So we got B, appellant received ineffective assistance of counsel when counsel allowed appellant to sign factual allegations that were not supposed to be part of the plea. So now we're getting into this number 8 issue, the personal knowledge. I think that was the McDonald's thing. Do I still have that up here? Or actually, I'm sure they'll... I don't know if I still have it ready to go, but I'm sure they're going to spell it out here. So Mr. Sledge's counsel also provided deficient performance, which falls below the standard of reasonableness, by allowing Mr. Sledge to initial factual acknowledgement number 8 during the plea, which the parties had previously negotiated out of the agreement because it was untrue. This error caused great detriment to Mr. Sledge, especially during trial. And this is critical because number 8 is one of the points that they said that this is where Sledge was being inconsistent. And if I'm not mistaken, didn't Whitaker specifically ask about the issue with number 8 at the revocation hearing? So if it never should have been there in the first place, like the attorney could have prevented this whole spiral. But this error caused great detriment to Mr. Sledge, especially during trial and the probation revocation hearing. Counsel testified to this error during the initial trial of the indictment and at Sledge's probation revocation hearing, and admitted the emails between himself and the state into the record. Counsel's failure to correct this error during the plea process fell below an objective standard of reasonableness, and the plea process would have been completely different had Mr. Sledge not admitted to factual acknowledgments that were not true, especially when the state filed a revocation action against him for testifying against the factual allegations at trial. For these reasons, Mr. Sledge should have the right to withdraw his guilty plea in order to correct a manifest injustice. I actually expect that the state in their response here is going to spend way too much time addressing this, because this gets into the pride of Adrienne Love. She took major issue, and it was my take, my personal opinion, that that first day that we saw Derek Wright pop into court, and he was trying to clarify, like, oh, it was a misunderstanding. We don't think it was anything intentional. Sledge is sitting on the stand, and Love is swearing up and down that she didn't change anything. Nothing was missed. These millions of emails weren't confusing to anybody, that everything was done proper and knowingly and with clarity. Wright caved and didn't want to go to bat for his client in that moment. And I feel like the state is going to have a field day trying to play into, well, he said on that day, he even said in court, he told the court that he doesn't think that Love did anything wrong. They're gonna love this issue. They are gonna love this issue. Argument 9. Appellant received ineffective assistance of counsel when counsel failed to object to false criminal history information being read into the record by an unsworn witness. Mr. Sledge received ineffective assistance due to counsel's deficient performance during the probation revocation hearing. For this reason, his probation revocation should be overturned. Claims of ineffective assistance of counsel are evaluated under the Strickland standard. The trial court's factual findings are subject to clear error review, while its legal conclusions are subject to de novo review. After Mr. Sledge testified at trial, the state filed the state's motion and petition to revoke probation. A hearing was held on the motion on October 18th, 2024. At this hearing, counsel represented Mr. Sledge and provided ineffective assistance of counsel by failing to object to prejudicial and incorrect criminal history information being read into the record by an unsworn witness. In order to prevail on a claim of ineffective assistance of counsel, Mr. Sledge must carry the burden under Strickland v. Washington of demonstrating that counsel's performance was not reasonable under the circumstances, like professionally deficient, and that there is a reasonable probability that, but for counsel's deficiency, the result of the proceeding would have been different. Now, you guys remember, I'm not trying to judge the chat for their judgment, but there was a shift in, we're going to call this the room. The vibe in the room shifted when I think the term sexual battery was read out by the probation officer. You could see it in the chat. Wait, what? Ooh, no bueno. The aversion. That, like, instinctual aversion, hearing that somebody did something, that it's taboo, it's heinous, it's Law and Order Special Victims Unit. That reaction, I mean, people are human. Judges are human. That type of visceral reaction, that's the heart of what we mean by something being prejudicial. Like, you could feel it shift. And it wasn't even true. It wasn't correct. So, and that there's a reasonable probability that, but for counsel's deficient, the resulting proceeding would be different. During the probation revocation hearing, after both sides rested regarding factual arguments about the allegations, the court asked to hear about Mr. Sledge's criminal history. After Officer Jolly was then allowed to testify on the record without being sworn in about Mr. Sledge's criminal history. And let me pause here. Because I'm missing a layer of my little rant there. We were sitting there and we were waiting. Is that really true? What do you expect? If something's said in court, and especially this is not like a direct examination and cross-examination moment where sometimes you have to wait hours or a whole day for the other party to have their chance, right? To counter something. When something's objectively untrue, not in evidence, you get an objection right away. If it wasn't true, you would expect that the attorney would say something. And I know we're not literally in the room, but on stream, looking over to the table to see if they're going to raise their hand, they're going to stand up, they're going to go to the mic and say, hold on, what? And that silence can be taken as an acquiescence, because they're not objecting to what was just said out loud, it must be true. So the lack of action from the attorney, I'd say, is very impactful. So, and it looks like they get into it here. So after both sides rested regarding factual arguments about the allegations, the court asked to hear about Mr. Sledge's criminal history. Officer Jolly was then allowed to testify on the record without being sworn in about Mr. Sledge's criminal history. Officer Jolly incorrectly testified that Mr. Sledge had used his first offender status 3 times. She read into the record, and again, this should have been objected to. This should have been objected to because this impacts sentencing timetables and You know, you've given so many chances, and here we are at another chance where you're not doing the things you're supposed to be doing. We have discretion as judges. I'm going to lean a little bit more this way because you've failed. You've used first offender status as a benefit 3 other times. No more Mr. Nice, Mrs. Nice judge. Right? So this is incorrect. This is extremely impactful. She read into the record conviction, we're going to just call it 83, for possession of cocaine and possession of intent to distribute. However, that case belongs to Anthony Bernard Sledge, not Antonio Sledge of this case. Officer Jolly then incorrectly stated the charges for Mr. Sledge's 94 case and testified that he was convicted of aggravated sex battery, which is false. He was never charged with aggravated sex battery nor convicted. Counsel for Mr. Sledge failed to object to the false information about his client's criminal history, which the trial court took into consideration in its revocation sentencing. Man. Counsel's performance was not reasonable under the circumstances and was professionally deficient. And I know it's not material here, but it was live streamed, right? So, like, oh my goodness. Like, what if so much appreciation for Jim? Because what if we'll just make up another person? What if there was no Jim? There was a Josh. Jim and Josh. There was a Josh. And Josh was like, man, what they're doing is really effed up. I want to help MOUNK TOUNK. But then they hear this, oh, he's had all this history. Rap sheet is huge. Sex battery. I'm out. I'm not advocating for this guy. And we never get here. Because the person that would have advocated for him was misled by something that wasn't correct to say, look, there's other people that I'm going to dedicate my time to go helping. This was out loud. Trial that hundreds of thousands probably watched. I think a lot of people paid attention to this revocation hearing. I mean, it happened at the end of a trial day, right? So even if people didn't know it was coming up, they could have continued watching because they were watching the court. In another universe, in another world, those prejudicial misattributions of a criminal record to Sledge, which were unobjected to by his attorney, could have led to this being a dead end. Nobody wanting to raise their hand and fight this battle for MOUNK TOUNK. So, counsel's performance was not reasonable under the circumstances and was professionally deficient. The trial court was gathering evidence to make a decision about Mr. Sledge's punishment for what the court found to be a violation of his probation. It was deficient for his trial counsel to allow false information to be provided by an unsworn witness to the court about his criminal history. There is a reasonable probability that, but for counsel's failures, the result of the proceeding would have been different. The trial court weighed Mr. Sledge's criminal history into its decision on the length of a sentence, hearing that a defendant had the benefit of first offender 3 times, a conviction for possession of cocaine and distribution of the same, and an aggravated sex battery charge certainly played a part in the length of sentence the trial court chose as punishment for Mr. Sledge's presumed violation of probation. For these reasons, his probation revocation should be overturned. So, in conclusion, and what do we want? The court should vacate Mr. Sledge's convictions because his guilty plea was not knowingly entered. Mr. Sledge and the state... Oh my god, chat! Oh man, this is in parentheses, guys. Mr. Sledge and the state clearly did not understand the nature of the charges he was facing. In violation. This is beautiful. I love this. Let's make this a heart. This is beautiful. And the state. In violation of his right to due process. And by the way, guys, this little extension is called page marker. And it has all these little... What else can we do? We can type text too. Oh, that's cool. Move it around. So, totally cool extension. If you guys want to know what it is, it's called Page Marker, and the logo is like a little red marker. I'm using it on Microsoft Edge, but I'm assuming it works on all the other browsers that things are often designed for. But it's awesome. So let's see. He did not understand the nature of charges he was facing in violation of his right to due process. Additionally, Mr. Sledge's convictions, I can't believe that's so great, should be vacated because the trial court failed to inform him that it was rejecting his first negotiated plea agreement, which also violated Mr. Sledge's due process rights. Lastly, Mr. Sledge's convictions should be vacated because he was deprived of effective assistance of counsel during plea negotiations and the plea hearing, resulting in Mr. Sledge entering a guilty plea to a crime not alleged in the re-indictment. Alternatively, the court should vacate Mr. Sledge's sentence to both count 1 and count 30 because the sentence imposed on count 30 was illegal and void, and the sentence on count 1 was imposed pursuant to a package deal. And I don't know why, but I think there's so many good arguments here, but this package deal thing just really pisses me off, like, because it was raised early on in to the trial court, and it just, to me, it just seems so obvious. Like, of course, if sentencing is supposed to be withheld for one on the basis of the other, and how are they, how is it not a package deal consideration? The court should also vacate Mr. Sledge's sentence to both counts because he was denied his right to counsel and to be present at his resentencing as no sentencing hearing was held. Alternatively, the court should vacate Mr. Sledge's sentence as to count 1, which was imposed in violation of the prohibition against double jeopardy. Interesting. Alternatively, the court should vacate the revocation of Mr. Sledge's probation because the trial court did not find Mr. Sledge to have violated any special or general, the parentheses are killing me, conditions of probation, rendering the 5-year sentence imposed pursuant to that revocation illegal. Absent such allegations and the subsequent finding that such violations had occurred as alleged, the trial court's revocation of Mr. Sledge's probation runs afoul of the applicable due process requirements. Separately, the court should vacate the revocation because Mr. Sledge was deprived of effective assistance of counsel in connection with his revocation hearing, given that Mr. Sledge's prior counsel failed to object to incorrect and highly prejudicial unsworn testimony. Also violative of due process was the trial court's taking judicial notice of Mr. Sledge's testimony. This violation also demands vacatur of the revocation of Mr. Sledge's probation. Underlying these many enumerated errors is a single, inescapable truth. The God's honest truth. That the state's prosecution of Antonio Sledge has fallen far short of fundamental fairness. To the contrary, every phase of the state's prosecution of Antonio Sledge has been riddled with significant defects. They got it. Jim got it in. R for riddled in the chat. R for riddled. W's for Jim and Tiffany. They really said their prosecution has been riddled with significant defects. Yeah, this is nice. This is amazing. Oh, man. Shout out in the most neutral way ever to Simone Hilton for the riddled with bullets. Oh, my goodness. Riddled with significant defects. I'm telling you. Why do we get together and read motions? It's so boring. No, it isn't. No, it isn't. The court should remedy these defects by granting the requested relief. Word count certification, they have to meet the formatting requirements. This submission does not exceed the word count limit imposed by Rule 24. Respectfully submitted. We've got... No, where's Jim's signature? All right. So we don't have Jim on this paper. We've got Tiffany. So no claps for Jim. We're only clapping for Tiffany today. So there we go. Oh, man. Oh, I cannot wait to see this continue on and play out. What a beautiful paragraph here. This is... Let's put a giant because we're using this pen. I'm not a good drawer of hearts. It's a little lumpy and lopsided, but so are human hearts. Human hearts aren't symmetrical, so we're fine. Oh, but I love this a lot. Love this a lot. This was awesome. The shade is shady, and I love good shade. It's very hot, you know. Win, Jim, and Tiffany. Poor Sledge. Amazing that he has these amazing attorneys and advocates in his corner. Just wonderful, wonderful stuff. It's riddled, but not Hilton riddled. We like riddled when anybody else says it. Oh, man. Also, I saw that we had, let's see, Michelle said, can you remind me why they needed MOUNK TOUNK on the stand? Was his plea not admissible? Torture. Make it seem like friends were turning on. Well, they wanted a few of the beef with the Shell Kell side, right? We're fighting with the ops over a paramour, over a girlfriend, right? So we wanted to establish that Antonio Sledge is, and Quindarius Zachary, and Demikian Garlington were affiliates associated with YSL, that YSL is a gang, and that they were having beef with the ops, granted in relation to a female, and to a paramour, whatever definition love wanted to go with. And they were shooting at the ops, right? Known ops of YSL. But then they also had the other information which was critical of this whole, after the shooting of Donovan Thomas, there was this whole McDonald's story where people go and they get together at this McDonald's and then they go get together, the switching of the cars, but a select set of people were supposed to be together. They go to this McDonald's, they talk about what just happened. They go to the house to meet up with Jeffrey Williams after this McDonald's trip. And Antonio Sledge, in his acknowledgments, particularly that number 8, substantiated that. It was an acknowledgement that he gave, and I think we also had the acknowledgement from others. Yeah, we went this was all a plan. We met up to apprise each other of how it all went down after the deed was done. So that was another purpose of the plea. What makes it admissible is, he was able to take the stand. If he wasn't taking the stand, they would have had an issue dealing with it. But because he took the stand, the defense was able to cross-examine, confront him. So, but yeah, I think a big part of it was also to make it seem, the state did want to make it seem like friends were scared. It was weird. The state, when they weren't getting answers from these plea deal witnesses that they wanted, suddenly it went from, these are people that turned on YSL. It would switch to, and you see the defendants sitting in the room here, as if to show that the defense is scary and intimidating them, and that's why this witness isn't wanting to agree to the things that they said when they signed the paper back in December of 2022. So the state switched depending on how the testimony was going, what they wanted to make these witnesses seem like. But yeah, they should have known he was going to explain more on the stand. But I think Love's strategy was drown them out with hours of footage and recitations of transcripts from the plea hearing to make the plea hearing stand out more. And I think that backfired, because I really think a big consideration that the jurors took into place was the way that the state weaponized plea deals. So them putting so much emphasis on what you told us in December 2022, I think it crumbled their own case. They tried to bolster it so much that it looked ridiculous. Yeah, where's the McDonald's surveillance footage? We'll never know. We'll never know. Big Nick is in the building. I mentioned you yesterday, just talking about panel collaborations, because I noticed that Twitch has a feature where you can actually let the chats come together. But it's only on Twitch. It's not like a feature that, like, if we syndicated a stream together, in the back end, we could see all the chats come together, but the viewers in Nick's channel wouldn't be able to be in the same chat experience as you guys here. It's separated, but Twitch is bringing the chat together. So we'd be able to syndicate one stream you could watch on either channel, but you'd be able to see all of the chat members. So I used you as my hypothetical, Nick. It's been a while, but you're the first person I think of when I think of a panel. Good to see you, and thank you for the super. And guys, you already know the drill. Yesterday when I popped up, we talked about that messy double exoneration story almost, where this guy gets acquitted after an overturned conviction for one murder case, and then wins a dismissal from a judge after a motion for a speedy trial violation for a totally separate murder case. We looked at that yesterday. But you guys were like, I miss you. Nick is always creating content and covering stories that you guys are interested in. So if you aren't already following Nick, there is his link in the chat. Make sure you go do that. Hit the bell so you know when he's going live. And then and this is so great, we're back to your original name because of the username here, but we've been calling you STS. STS is joining us today. I think this is, let's see. This is one of the most important things, I think, for STS to hear. STS was the other person back in the day. Angrily, not really angrily, you're the more stoic person, I would say, compared to Jim, but equally as emotionally invested in this. What the heck is this garbage that they're doing with MOUNK TOUNK and this plea deal and the way they're structuring this agreement? It's not right. So we're moving forward to the stage here. We're now at the appeals court level, and it's been months in the making. I mean, we're a month and change away from October 24th. So it's almost a year since the revocation. Isn't that crazy? A year that Antonio Sledge is in custody because of all of this is 67 pages of garbage behavior and garbage carelessness and maybe intentional misleading by the state, naivety of defense counsel at the time, and carelessness and whatever of both trial court judges. So it's great to have you here, STS. STS also gifted 10 memberships, which is super nice. I saw you guys saying thank you already. So big thanks for saying thank you when people are so kind to, donate and gift. It's fun for the chat. It supports me and, our time that it takes to do these streams and videos. And it's really something that nobody has to do. So STS, you've always been so generous with the gifting in the chat. So tons of love for you. I know the chat loves you too. Hope you're doing well. Whew. But we did it. I think the only flaw with this, if we had this a little bit shorter, let's see. If this just fit on this page count wouldn't be 70. We missed the internet joke. But there we go. I'm going to drop the links to this filing again. There's a lot in it. Again, it's searchable. So if you want to revisit anything, let me share this over on Twitch as well. Shout out to the Purple Gang over on Twitch. It's there in the chat. If you're on replay crew, missed ya here in the live chat, but there's a bunch of links for you guys in the description. I try to make sure to put everything that we need in there as well for you guys. But yeah, I'm passionate about the issues. I like the way this was written. I'm giving it a 10 out of 10. 10 out of 10. It's a yes for me, dog. So, any final thoughts, you guys, on, what argument do you like hearing the most? What do you have predictions? Do you have predictions about what the state's gonna do in their response? I feel like I'm gonna need to get a sound effect just for the state's response when we read through it. Like a womp womp sound or something. We'll have to see. And then I also want to pull up. That's what I was putting down there, Keisha. We were 1 page away. We were 1 page away from being a 69-page count. For the internet, for the internet. Do it for the chat. And let me see. And also, of course... Oh, LNA. I just opened X because I was gonna go grab Tiffany and Jim's links, and I see my notifications. L&A got their working and lurking mouse pad, and we got a bonus cat picture here. This is awesome. It looks great. I'm so happy. I hope you love it. Look at that, guys. So shout out to L&A. Love it. Anyway, let me get let me get Jim and Tiffany's profiles. Okay, so Tiffany/Fit. I'm going to try to use both of her names until we all know who I mean by what. And then and I highly recommend, there's a million reasons to check Jim's profile. He's pretty active over on X, but he always has an interesting cover photo that calls out some fun stuff from documents. It's always a good time. So this is Jim, or How. And then, yeah, Nick, shout out to the Cardi B trial. That really was a good time. A hot mess of a trial. It seems to me that client really thought she had a chance and continued to want to take it to trial. I would have dropped that. If I was the type to go out and seek a settlement and I didn't get that settlement, I would try to get my butt out of that case before it went to court. You had this defense attorney. I mean, why am I calling defense attorney? The plaintiff's attorney. That's my mind saying I think the plaintiff was the one in the wrong here. I think this was frivolous. So my mind went to calling her the defendant as if she was the one facing repercussions for something. But the plaintiff, Amani, accusing Cardi B of assaulting her during an OBGYN visit. The plaintiff's own attorney is out there like putting talking about vaginal discharge and repeating it over and over about his own client. What was the point? You're putting me on blast on a global stage. Do you know how many people tuned in because they love Cardi B? How many people tuned in because they hate Cardi B? How many people tuned in just because it was a televised trial with a celebrity in it? And you're out there, man, I don't want to go forward with this case. Take me out. Take me out. Oh my gosh. But it was a time. And again, it's a civil case. It was the worst allegation was intentional infliction of emotional distress long term, which an expert witness came in and was like, no, when I did my evaluation, this is all consistent with malingering, which is like feigning. It's not, you're putting on the symptoms because you think that will satisfy passing a test, an evaluation, to help you prove that you are experiencing this emotional distress, these inflictions, stemming from this incident you're alleging somebody else incurred upon you. And a scratch to the face, that there was inconsistencies. At some points in time, she was saying it was to the nose, and then she said she didn't have a scar on the nose, and then it was to the cheek, and she had this expensive surgery years later, and this whole case is coming to trial like 7-8 years removed from when the incident actually occurred. In my opinion, I think we had a bold security guard that was running up as an employee of this medical office, this building, hearing that Cardi B was there and wanting to get a video of someone being there. So, but yeah. I don't know why that attorney took that case, but he did, and his client wanted to move forward, so. But it was a 4-day trial. I think it was 4 days. There were some breaks you could skip. You could probably get through speed watch. Flesh of the Gods covered it and is where I mostly watched it. I didn't know the first day there was a day I didn't know he was covering it until Lexi the Law Nerd shared. So I missed one of the days over there and was watching it over, I think with just Law and Crime or Court TV, one of them. And it was weird to watch without commentary, without... I don't consider their chats to be the same as like chats on a commentary channel. And whatever that day was before I found out the Flesh of the Gods was covering it, I was like, nobody's reacting like the way I would expect them to be reacting. Whether they feel one way or another about the plaintiff or the defense, there were just crazy moments across the board in the trial. And I felt a little bit homeless watching it. I felt like I was plucked out of my home base watching it over with Law and Crime. Although I do appreciate them for having their streams, of course. Oh, man. Neri says, like, that case was so goofily frivolous that it made me wonder if Miss Love had started doing civil work. And there you go. There you go. Oh, that would be a time. That would be a time. So we're going to wrap it up, you guys. And I think, hold on, someone else said, Mel, I'm not a lawyer. Wait, you know what? I think Verdict Mel, Millionaire Mel, also did Cardi B coverage. Because there was a day where I was like, okay, I'm going to watch Cardi B with Flesh of the Gods. And then I'll go catch up on Donna Adelson, which honestly, I stopped following Donna Adelson. I feel like that's like a showboating. You got her. Like, I feel like this is a long, drawn-out trial with great presentation, don't get me wrong. But it's a little bit like, bro, this is like years removed from the actual murder. Wrap it up. Wrap it up. Get these people and make your decision if you're going to arrest Wendy or not. Holy moly. So I kind of lost interest in the Donna Adelson. There's nothing that's that interesting, scandalous, surprising. It's just dragging, if you ask me. But I wanted to go catch up with it over in Verdict Mel. And I go and open, and they're all watching Cardi B, because the Cardi B case was just that magnetic. So I think Millionaire Mel, I call her Verdict Mel because that's her Twitter handle. And then I'm Not a Lawyer But Melanie. Two different and amazing Melanies both talked about Cardi B. So let me get all their links. You guys can go check them out. And I think both of the Mels also do TikTok. I'm starting to use TikTok to follow what you guys are doing. I'm not really uploading anything on TikTok. But if you're on TikTok, I do really like both Mel's content over there. So first is Millionaire Mel. I'm just going to put Millionaire. And then I'm going to put Not a Lawyer Mel second. And then Flesh of the Gods. There you go. So there are those three channels you can go catch up with. I don't think Flesh of the Gods is doing Donna Adelson, but I think both Mels are covering Adelson updates as well. Again, we talked about Justice Served TV earlier today. They are currently live. We might redirect over there. I'll drop their link right now. Unless if you guys want to shout out anyone else who's... I think all of the coverage right now, like the case coverage right now, is focused on Adelson stuff. And, to be honest, me saying I'm not interested in it, take that as a compliment to a prosecution. I love to tune in when an attorney is messy, or I think that they need a microscope a magnifying glass over what they're doing. So me not being interested in something is not a negative statement about how the trial's proceeding. Like, if the judge was interesting, if the prosecution was doing something interesting, scandalous, I'd be like, ooh. So it's a positive thing that I'm not interested in it. So I like things that are exceptional or like reach a certain level of what is happening level. And then let's see, we've got, if I were to try to redirect, what options do I have here? Who's live? Ooh, Judge McBurney's live. I wonder if Dolly's live. Dolly sometimes... Let me get Dolly's link. So Judge McBurney streams his court cases. No, I don't want Salvador Dali content. I want Dolly Talk the channel. Okay, yep. So Dolly, daily, guys. This is a daily thing. And great chat over there. Right now it's focused on Judge Simpson, but McBurney's in the though. I can just switch over here and show you. But you can see he does, right now it's focused on Judge Simpson in the title, but you see McBurney's here too. But courtroom roulette. So when there's downtime, they hop to different court feeds. A lot of it are like sometimes arraignment, misdemeanor hearings, plea hearings, whatever. Really interesting and jumps around, so there's never a dull moment with a good chat. So I highly recommend, if you're looking for something to do when there isn't a major trial or a trial that you're interested in, or you just want a break from serious, heavy murder trials. Dolly Talk and his mod team do a great job. And they'll give you the context. When somebody comes up, if you give it like 30 seconds, you'll get like a pinned comment that tells you what the charges are, you know, any other specific information that's worth knowing. It's a really, really cool environment to watch little bits and pieces of kind of everyday court proceedings. So definitely check out Dolly over there. And thank you, Factual Lie, for... Where'd your comment go? Oh, it's pinned. It's already up here. About McBurney's trial feed. So there we go. And then as far... We can get over to Donna Adelson coverage. Let's see. I'll probably pop into this roulette and I'm sure I'll get a peek at what McBurney's talking about and Simpson and a few other judges. I'll catch a Donna Adelson recap. It's not scandalous enough for me, guys. I feel like a lot of the tea and weirdness about Donna Adelson is like, I've seen it all on X and Twitter already. Let's see. So this is set up to take us over to JSTV. Again, use one of those links if you want to hop somewhere. Oh, they're on lunch break right now? Okay, so if they're on lunch, let's do the redirect over to Dolly. We'll do this courtroom roulette. But, you know, I don't know when they do their lunch break timings, but maybe in like 30 minutes, guys, check over to Justice Serve TV for Donna Adelson. And there's really like my entire like suggestions are coverage of Donna Adelson's trial. So there's plenty of options there to choose from. While they're on lunch, we'll jump over to this courtroom roundtable. I think it'll be a good time. If you're over on Twitch, again, you'll have to come over to YouTube, look up one of these things and come hang out with us. Thank you for hanging out over on Twitch, you guys. I'm going to get more organized and figure out these different features. I've only really been on chat side over on Twitch and then in backends to pull clips for people, which isn't the same as moderating and looking at the features. It's just clipping content. But I do want to thank, I saw Factual Lie said earlier, I saw it over in the StreamYard chat, that she said she was able to get her Amazon Prime to give her the free membership over on Twitch. So thank you, oh Bailey's. Factual Lie, I gotta use both names now. And HTX Voodoo was over there cheering with bits. I don't even understand what bits are, but there's something, so thank you, HTX. Oh, so this is going to be a good time. There's a lot for me to learn over there. But I'm excited to pull up some fun games and see what we can do. And again, the content over there will syndicate to both when we do trial streams, so you can choose what viewing experience is the best for you. But like these video stories, these uploads, like videos on demand, probably will all stick to YouTube. I'll try to keep this focused on wrongful incarceration stories, overturned convictions, live trial streams. And then over on Twitch, I'd like to do a little bit more reaction commentary, like what are people doing that isn't always necessarily taking place on a docket or in a courtroom. So it'll be a good time. Whatever floats your boat, hope you join us wherever you please. And let's get over to Dolly's stream. Let's go check out some other judges. And perfect. So 2:15 p.m. So about 25 minutes from now, you guys, is when Donna Adelson's trial should be back from lunch. So thanks, Coley. Is it Cole Kid? I think it's Cole Kid, but I could be pronouncing it wrong. So thank you so much for the timestamp on the lunch for Adelson. So 25 minutes from now, search up Justice Serve TV and go check them out when they're back from lunch. But thanks for everyone for hanging out. We'll be back with any MOUNK TOUNK updates, and maybe on the 8th if there's updates with the Takapina, ASAP Rocky, and Relly civil litigation. So I think that's the next thing on my radar. Hopefully nothing crazy happens between then and now, but see ya eventually, you guys. Love you. Have a good one.